it's always been a very good experience, because it helps to also make me refine, my own craft, as well as I'm, forced to have to think through as I come to speak to people who I know are not lawyers like me. So it helps me to be able to better conceptualize, what are ordinarily technical legal matters, but really this is what it should be, because at the end of the day, we lawyers, we don't exist for ourselves. We exist to provide services to people like you, who are the ones who would take this information out there, use it to, run your businesses, make your businesses successful. And then that is when, the loop is really complete in terms of the provision of legal services by us lawyers, when the end user has made sense of it and it has become something valuable that is able to affect your bottom line. So what I'll do before starting class, because I want today's class to be very interactive, I would like to know each one who is participating in this class. So, and just a quick idea of the industry you are playing in or you want to play in. So that helps me to give examples that are most relevant, and particularly when we get to the Q&A and the practical sessions we are going to discuss, we can begin to engage and really see how these things in the practical sense would play out in your industry. So what I would do, I would call the names as I see them on my screen. You just quickly, okay, I already have your name. So what I want is just for you to give me a quick idea of the industry you play in. If you just call the name agro, and then maybe I may ask a follow-up question just to clarify and to be sure I have a clear understanding of what your area is. So I guess I'll start with the first I see as Amua Stephen.
Yeah. Good afternoon, sir.
Yeah, afternoon.
Yeah, I play a very vital role in the EPC industry, engineering,
EPC.
procurement, yes, engineering, procurement, and construction.
And construction.
With
okay.
Special focus on renewable energy.
Oh, okay. Oh, with emphasis on renewable energy.
Renewable energy.
Okay, good, good. Thank you very much, Stephen. Then the next I see is Apa Thompson.
Okay, good evening, everyone.
Yeah, evening. Yeah, evening.
Yes, I actually am in the energy sector, but I've been exploring more on the developmental space. So
okay.
I actually have been doing some work with Octoville and more into the NGO, so consulting for NGOs, yes.
Okay, so is your focus on what, like rural electrification?
Well, when I say energy, my core competence is on nuclear energy.
Okay. Oh wow.
I also have interest in renewable energy also.
Okay.
Yes.
Wow, that's interesting. So at the moment, what is the core of your work now? Because nuclear energy is not a big thing in Nigeria yet. So what area does your interest, your current engagement actually address?
Okay, well, it's because I work with the Nigeria Atomic Energy Commission.
Okay, so you also license things like X-ray machines and the rest, right?
So yes, we promote nuclear atomic peaceful uses of atomic sources.
Okay.
And that has to do with radiotherapy, nuclear medicine, agriculture. It spans across all those sectors. Yes.
Okay, that's interesting. Thank you very much, Thompson. And then, of course, our Deborah, even though I know Deborah is one of the facilitators, but also involved in the action. So, Deborah, you just give us a quick idea of the area you are playing in or you hope to play in, just to help me get more relevant examples.
Okay, so it's more of advisory, business development, and a little bit into the real estate, but it's majorly business development and advisory services.
Good. Thank you. Okay, and then we have Gladys.
Good evening, everyone. Currently, I play in the NGO space, donor management and engaging development. But on a personal thing, I do consultancy for corporate events.
Okay, for events, corporate events. Okay, so that'll be things like major corporate events, AGM, for instance.
Yes, exactly.
Okay, Okay, great. Good to meet you. Okay, and then next would be Justina Adamadi. Justina? Okay. Okay, I can see Wonder Gold. Your mic is already on, so if you could carry on, because it keeps flipping. So at least I can see Wonder Gold now. Yes.
Sorry, I'm just getting logged in back, sir. I didn't even hear what you said.
Okay. So let me explain. I just want to know what sector you're playing, in terms of what sector, either what business you currently do or you are looking forward to do. It gives me an idea of, to be able to give relevant examples as we go on.
Okay, so I'm working with MSMEs at this time, and I also work in the construction space, sir.
In where? In what?
I said I'm working with MSMEs, and I also work in the construction space, sir.
Okay, and construction. Okay.
Yes.
Okay, thank you for that. Then I'm just trying to ensure I've not skipped any word. I can see Nnamdi Chinyere. So yeah, Nnamdi Chinyere, you can carry on.
Good evening, sir. I just came in, so I didn't understand the first question.
Okay, sorry. What we are just trying to do now is just get an idea of what business sector you either are currently engaged in or you are prospectively hoping to get engaged in. It's just to give me an idea of who you are, what business you do, so that as the lecture is going on, I can give relevant examples.
I am currently working in the hospitality industry. I'm not having any business.
Okay, hospitality industry. Excellent. That's wonderful. Okay, so I can see Farida Yakubu.
Yes, sir. Good afternoon, sir.
Good afternoon. So just want to know what industry are you in?
I'm trying to get into real estate.
Real estate, okay.
Yes,
Okay.
sir.
Excellent. Then if Justina Adamadi is here, you can speak at any time. I had called on you earlier. Justina Adamadi. Okay, I can see.
Justina is in construction, just in case she can't hear you.
Okay, in construction. Okay, good. In construction. Yes, okay, good. Then I see James Duru. So James, what sector are you in?
Good afternoon, everyone. I currently work in the consulting sector.
Consulting.
Okay. I currently work in the consulting sector, and I intend exploring the cosmetic industry looking forward.
Okay, cosmetics. That's interesting. That's nice. So what, things like a shea butter value chain? Because I know that's one huge area of
distribution of cosmetic products.
Of cosmetics. Okay, excellent. That's good. Okay, and then Karim Adebayo.
Hi, good afternoon, everyone. I'm looking forward to explore the tech and precisely the software development.
In software development, okay.
Yes, sir.
Okay, thank you. And then let me see who next can I see here. Nnamdi, have I gotten yours?
No, sir. Yet. Good evening.
Okay, evening.
Okay. I'm in the pharmaceutical industry, but precisely retail pharmacy industry.
Okay. Retail pharma. Okay.
So we retail range prescription, over-the-counter drugs, health and beauty items, and toiletries.
Okay, thank you. And then Rejoice Azuka. Rejoice, if you can hear us, we'd like to know just a quick snapshot, what industry you are in. I hope I've not missed out anyone. Rejoice. And then there's Richard Jeremiah.
Yeah, good afternoon. I'm actually on the road, but I'm on hands-free. So can you hear me?
I can hear you, yes.
All right, so I'm a software developer. And,
software?
Yes, I'm a software developer.
Okay.
So I co-founded a fintech company just at the early stage. So we're still at our early stage.
Okay, so early stage fintech.
Yes.
That's okay. So Rejoice, I think is Rejoice and Lekanola. Those are the only two people left now. Okay, Rejoice is in a noisy place. Okay, so if you can just chat, Rejoice, your sector, and then I guess the person just came now, Lekanola. So just want to know what industry you are in. Okay, then there's also Stephen Chinedu. Yeah, so Lekanola, you can speak. Or Stephen Chinedu, any of you, you can speak or you can chat and just give us an idea of what industry you are in. I believe I have not missed, so the only two people I have not heard from now is Stephen Chinedu and Lekanola. So if there's anyone else I've missed, please feel free to just speak up so I can note down your industry, or you chat, you send in the chat box, that's also fine. So for the sake of time, we'll just jump into the lecture, but at any point in time, please, you could just introduce yourself, like I said, put in the chat box just so that I have the frame of reference to help, give examples that I believe would be most relevant. So today we are looking at business law 1. Yeah, so what we did last time was business structures, essentially looking at what structures you can use to run a business in Nigeria in terms of what legal vehicles are provided to run a business in Nigeria. So today we are focusing on contracts and documentation. So the first lesson will be on the essentials of legal contracts. Second lesson will be on legal documentation, and the third lesson will be on common.
I went to the time and I came back.
Okay. Okay, is this record? Okay. Okay, so we go into our outline for today. So lesson 1, we'll be looking at essentials of legal contracts, basic requirements, factors that affect the enforcement of contracts, discharge and breach of contracts, and then remedies for breach of contract. Then lesson 2, we'll be looking at different legal documentations, some of what we call the early stage documentation, memorandum of understanding, letters of intent, term sheets, joint venture agreements, exclusivity agreements, and then an agreement which I believe will be very relevant to our people who are in the fintech area, simple agreement, or people who generally support MSMEs, simple agreement for future equity. So it's a type of funding agreement, but which is very relevant to early stage startups. Then lesson 3 will look at third party. So lesson 3 just look at contract issues. What are some of these issues that typically arise in the Nigerian business space with contracts? So look at third party interest or privity of contract. I'll explain what that means, and look at guarantee. Then contract management, lack of it. That's actually what we're focusing on, because it's a huge area, particularly in the Nigerian businesses. People don't understand that once they sign an agreement, they think that's the end, but that's not the end. You need to manage that agreement. Then dispute resolution clauses and alternative dispute resolution, including particularly arbitration. Some of the gray areas that seem to arise with that in contracts in Nigeria. Then the capacity of foreign companies to enter into contracts in Nigeria, I would also look at that. And then the issue of damages, anticipated profit, and interest, how these issues play out in the context of contracts in the Nigerian business space, and some of the important things you need to note and have at the back of your mind. So we jump in straight away. We start with lesson 1. So what is a contract? So the simplest way I can define it, I'll use a Latin term to confuse you first of all before I further break it down. A contract in law is simply what we, is simply consensus ad idem. So consensus ad idem is a Latin word that simply means the meeting of the mind. So of course, you know the word consensus already. So that means the minds of both parties coming together and having a clear understanding. So contract really at basic is simply an agreement that is an agreement between two parties that the law will enforce and is binding in law. So for a contract to exist, it means that the two parties to the contract, when we talk of a contract, typically there may be multiple parties in the contract, but invariably contract is always broken down at the basics to a meeting of minds of two parties to a contract. There's also, of course, what we call tripartite agreements, and even agreements with 4 parties and all of that. But usually when you break it down to its barest minimum, you always find that a contract is always about mutual obligations and an agreement on those mutual obligations. So of course, as I discuss more, we'll break it down some more. So the basic requirements, and then just to put this note here, please feel free at any point to interrupt to ask questions. Contracts would be doing this for an hour, 30 minutes is the meat of what we are doing today. So we'll be spending the first 1 hour, 30 minutes on contract. So please feel free at any point in time to interrupt me, to ask questions, to clarify if you need to. So basic requirements for a valid contract. So to have a valid contract, there are some basic things that the law, would look at before it says, okay, what these guys have is actually a valid contract which the law would enforce. So the first thing is what we call offer and acceptance. And then, of course, I'd explain what counter offers are and what puff offers are. And then I put something humorously there that puff is not good for contract. And you'd explain, come to understand why we say puff is not good for contract. So an offer in law is simply an unequivocal expression of intention. So I want to sell you this bottle of water. So if I say I want to sell this bottle of water for 100 naira, that is an unequivocal expression of my intention to sell this bottle of water to you for 100 naira. So the terms are exactly clear. Now, an acceptance on the other side is an agreement to that unequivocal expression of interest that I have made. So if I say I want to sell you this bottle of water for 100 naira, I say, yes, I'll buy this bottle of water from you for 100 naira, it means you have accepted. So there's offer from me and there's acceptance from you, and that makes a binding contract. So like I mentioned earlier, that is consensus ad idem. Both of our minds have met and agreed that this bottle of water will exchange, will be given to you, and in return, you will give me 100 naira. So that's offer and acceptance. However, in real life, it doesn't always play out that way, because when I say I'll sell this bottle of water to you for 100 naira, you could counter and say, no, I'll pay 90 naira. So what has happened in essence is that instead of accepting my offer, you have done what we call a counter offer. You have expressed your own intention to say, no, I'll buy it for 90 naira. So at that point, there's no binding contract yet because there's no consensus. I'm asking for 100 naira, you are offering 100 naira. So it means that at that point, what has happened is that you saying you buy it for 90 naira, you have sent me a counter offer. So it is now for me to accept that circuit of fine, I accept, I'll sell to you at 90 naira. So it is at that point, so you can see that there was an offer, but instead of an acceptance, because the acceptance was not exactly a full agreement of everything I offered, it therefore became a counter offer. So it now becomes for me to now accept that counter offer before a binding contract will come into being. So typically this is what we call negotiation. So you make an offer, there's a counter offer. It could also be that you make me a counter offer for 90 naira and I say no, okay, I'll sell for 95 naira. And then the ball is back in your court. I say, okay, no, 93 naira. So we keep going back and forth, offer, counter offer, until somebody finally agrees what the last person says unequivocally. I say, okay, fine, deal, 94 naira. So once that acceptance happens, then offer and acceptance is complete, and then that is the point at which we can now have a binding contract. So when I mentioned puff offers are offers that are not, an offer in that sense. It's just a person being, just bragging in a sense, or saying things that are out of, that are not heartfelt, are not truly meant. So a typical example would be, you go, for instance, to buy a car, and the person is saying that, Oga, if you buy this car, the fuel economy is so good, Oga, there's no way you can use more than one full tank in less than 2 weeks. So imagine I now buy that car, I fill up the tank, and I now decide to take a trip from Abuja to Lagos. And then by the time I get to maybe Ibadan, I need to fill the tank. And then I come back to Abuja and say, Oga, I'll sue you. You told me that this car, there's no way I'll be able to fill the tank twice in a week. Yet, in just one day, I was traveling from here to Lagos and I filled the tank. Of course, I mean, at that point, you know that he didn't mean it in that figurative sense to mean that no matter how you use the car, you won't fill it. Maybe he meant if you use the car for normal, intra-city movement, you would need, a full tank to take you for, take you for 1 week. So a puff offer simply means the person is saying something that is just inflated. It's not real. He doesn't mean it in that sense. So it's an inflated offer. So inflated offers, I mean, you can't act on them in that sense, or they would not be taken to be valid basis for which a contract would come into existence. So another important thing about this whole idea of offer, acceptance, counter offers, back and forth is that in a practical sense, it gives you the basis to control the contracting process. So one of the ways you use that to your favor, particularly when you are the one who is giving out a contract, is to use, rather than make an offer. Because if you are advertising a contract, for instance, you're already making an offer. So if, for instance, you come and say, I'm willing to pay 1 million naira to anybody who can renovate my office space. And of course, our guys who are in EPC here, any of them comes up and says, I will do it for 1 million naira. It could be that by the time the person comes up, maybe I don't like him, maybe it's not the person I really want to enter into a contract with, but because of how contracts work, the moment the person accepts your offer, you are bound. You cannot back out anymore. And if you back out, you'll be in breach of the contract. I will explain further what breach of contract means and what the implication of breaching a contract would be. So because you don't want to get into a contract with somebody you might not want, or you want to
you cannot carry your earpiece,
or you want to choose amongst, you want to have the option of choosing amongst amongst many different service providers who you enter a contract with, rather than make an offer to those people. Leave this up. Go out and close the door. Sorry, excuse me, guys. Go out and close the door. Sorry, excuse me, my children were intruding. So to ensure you are able to control the process, you could rather do what we call an expression of interest, which is what happens typically in construction contracts. You don't just make an offer and say, whoever is ready to renovate my office, I'll pay 1 million. You rather say, look, come and submit either a request for proposal, come and submit proposals, or express interest in renovating my office located in so and so and so. So that way, what the people submit, that expression of interest form or the request for proposal, the proposal that people submit become the offer. Then you, the person who is giving out the contract, you now have the opportunity to now look through and decide who amongst them you are more comfortable dealing with. Then you can now, accept that person's offer, so that way you are the one who is in control of the process of entering into a contract. So that's one practical example, and we'll talk more about it as we go along. So the first thing now is that offer and acceptance is important to come into a contract, but that is not the end of the matter. So the fact that I made an offer, you accepted, and a contract comes into being is not enough to say we have a valid contract. The next thing we have to look at is, was there consideration? So I put there, just as joker, can an inconsiderate person contract? Now, when we say consideration, why I put that code there is that consideration is not the English definition when it comes to the law of contract. Consideration in the law of contract is a different matter. It is simply something that is sufficient in the eyes of the law, value in the eyes of the law, that is exchanged between the parties. So as far as a contract is concerned, two parties are coming together to enter into obligations. Each person must bring something to the table. You can't come to the table to contract empty-handed. That means, as I say, I'll give you this bottle of water for 100 naira. It means that as I'm giving you the bottle of water, that is what I'm bringing to the table. You are bringing 100 naira to the table, and I'm taking that 100 naira from you. So we are both exchanging something of value in the eyes of the law. The bottle of water is of value in the eyes of the law. The 100 naira is also of value in the eyes of the law. So to enter into to have a binding contract, it must be shown that both parties exchange something that was valuable to each other, before a valid contract comes into. So despite the fact that there's been offer, there's been acceptance, or the counter offers and all, and there's been a binding acceptance, the next question is that, did parties exchange something of value? Now, what is important in law is that consideration must be sufficient. That means it must be something of value in the eyes of the law, but it need not be adequate. Adequate means that if I choose to say, look, I'm going to sell you this bottle of water for 1 million naira, and you accept to buy it for 1 million naira, it is binding. You cannot come and say, but it's just a simple bottle of water now. Why should I pay 100 naira for it? So that means if you have struck a deal and you later go back home and find out that you were that the person had fooled you, that bottle of water is not worth 1 million, too bad. You are bound by that contract, so far as you have agreed it and it has passed. Now, this issue plays out more in undervaluation. So a practical example, you choose to sell a car and somebody strikes a deal and says, I'm buying the car for 100,000. And you later go back and find out that other people are saying, if you had told me I would have bought that car for 1 million or 100,000, that was too cheap. And you now come back and say, no, I'm not going to deliver the car to you anymore because I have somebody else who wants to buy it for 1 million. If you do that, you'll be breaching a contract and the person has the right to sue you. and would explain if he sues you what he can get from you, including insisting that you must sell that car to him. So that's why if I have somebody else who wants to buy for 1 million, you are going to be forced to sell to the guy who you already agreed to sell to and who has already paid you 100,000. You can't decide to sell the car to someone else. You must sell to him. So consideration, like I said, is something of value in the eyes of the law. So once it's of value in the eyes of the law, whether it is adequate is not the business of the law. So the fact that the 100,000 is not adequate for a car of that brand is not the business of the law. All the law is concerned is that, did you agree for 100,000? Fine and good. Now, of course, the law is not foolish. So sometimes the law would know that this contract looks suspicious. How could somebody sell a brand new BMW for 1 million naira when the same BMW is, currently not less than 25 million naira? So the law would only say where the consideration is inadequate, it raises a presumption that there may have been fraud, there may be deceit, there may be fraud, there may be something untoward happening there. But otherwise, on the face of it, the law would enforce that contract. So another implication of this is that when you enter into a contract with someone and you are not sure that in return for what the person is promising you, you are giving the person something that seems valuable or is adequate, what you can do sometimes is to put what you call a nominal consideration. A nominal consideration is simply just to fill up that sufficiency gap, not the adequacy gap. So a practical example would be, for instance, when government sold the power plants to the generating gencos, that's the generating companies, to investors. Part of what the investors negotiated in that agreement was that, look, in case at any point in time we are tired of this business and want to back out, we have the right to sell those power plants back to government, and the price that resale would be at is I think was fixed then at $1,000. Of course, you know that no generating plant is as cheap as $1,000. I mean, a generating plant, it would be priced upwards in billions of dollars. But what they were doing by that negotiation is simply to make sure that if they compel government to buy it back from them for $1,000 and government decides not to buy it back, that $1,000, once it is paid, automatically is a binding contract and a binding obligation for government to take those plants back from them. So you could see that why they did that is simply to avoid the situation where it would be said that them trying to enforce the agreement to force government to buy back the contract for them would be said to have been done at no consideration. So that 1,000 is just a nominal consideration. It's not adequate because that's not the true value of that asset, but it is is sufficient in the eyes of the law to ground the obligation of government to buy back that plant from them. So in your own business transactions, you could use this where you are not sure where the promise the person has made to you. There's no counter promise from your own end. So you could simply say, look, for 1,000 naira or 100 naira or whatever, just something of value to ensure that you are able to hold the person's hand and bind him to a contract. So as we go on, of course, we'll be giving some more live scenarios to help knock this in. But essentially, always watch out, particularly when you are on the end of a contract that doesn't seem you are giving much in return for that contract. Put a figure there just to ensure that the law would enforce that contract. Now, however, just the way the law operates is that the law can be funny. So after you have offer and acceptance, you even have consideration. It is not still enough to say there's a binding and a valid contract. You now move to the next stage, which is intentions to create legal relations. So it could be possible there's offer, there's acceptance, and there's even consideration, something of value exchanged by both parties. But the question is, in the context in which that agreement was made, would it be found that the people were serious and wanted to enter into a formal agreement to create a contract with legal obligations? So one area where this could easily play out would be, for instance, in context of family relationships, for instance. So if I tell my son, I'll buy you a car if you are able to take first position in your class. Now, I made him an offer. He has accepted. I said, okay, Daddy, I'll do my best. I'll make sure I take first this term. Now, there's some sort of consideration because he's going to put extra effort to read extra hard to ensure he takes first. So there's consideration. And he now does it and comes back and says, where is the car you promised me? And I say, young man, go and sit down. Which car? You are too young. When you become 18 years, I'll buy you a car. And then he decides to get angry and says, in fact, Daddy is not keeping to his word. I'll sue him. and it takes me to court. Yeah, there was offer, there was acceptance. In a sense, there was even consideration. But the question is, even the judge the case comes for is going to ask himself, between a father and a son, I don't think at the time they were discussing this, they truly, genuinely intended to create legal relationship between them. So you could see that even though there was offer and acceptance and consideration, that would not be a valid contract in the eyes of the law, because in the context in which it was made, it's assumed that there was no intention to create legal relations. So even in business, this could actually play out, because I mean, you are doing business with somebody who maybe there's a family relationship involved. So for instance, when a father, you want to give a gift, for instance, to your child, and you want that gift to, you don't want a third party, maybe you die, and then your brother or your other people come to intervene and say, no, there was no valid contract between you and this child, because after all, it's your son. So how could you have said you sold this building to him at XYZ amount? So the idea, one of the things you do to ensure that you are able to make that contract valid and binding, so that no third party is able to nullify that contract, is to put a consideration. So you could say, my son is buying the building for me for 10,000 naira. That becomes valid and binding. Now, one area where this could be important, for instance, is where a man dies and leaves a lot of debt, and his debtors come and say, look, part of these assets he has that I want to take over includes this building that he has in Onitsha market. And he says, no, before he died, he sold the building to me, because that's the son talking now. Of course, the people are going to say it's not true. The contract between you and your father to buy this building from him, did not have intentions to create legal relations. Of course, the evidence you could do is to say, look, I actually paid him 10,000 naira to buy that building. Of course, like we say, the law will not look at the adequacy of that 10,000 naira, whether the building was worth 10,000 naira, provided that contract was had a consideration which was actually paid. It would negate, it would show, for instance, that there was intentions to create legal relations. Another way to ensure that your agreement is not nullified for lack of a showing that there was intentions to enter legal relations is to do the contract by what you call a deed. A deed is simply a document. It's like any other agreement, but the difference between a deed and a regular contract or a regular agreement is that a deed is signed, sealed, and delivered. Now, in those days, signed, sealed, and delivered had a technical way you do it. So for a deed to be sealed, you put wax on it and you put your ring. We know how they used to do contracts in those days, or a symbol, or sometimes you emboss your fingerprint on it. So that is a seal. So that usually would be candle wax with a unique, maybe a ring or the finger impression of the human being in question. Of course, in modern world, we no longer do those things. So signed, sealed, and delivered in modern world simply means an agreement that states on its face clearly that this is a deed and it is signed, sealed, and delivered. So the moment you put your signature on it, it becomes what you call a deed. So a deed is not a regular contract. A contract is just an agreement written in a written form and signed. But a deed is a contract, that's an agreement in written form, but that expresses that this agreement is signed, sealed, and delivered. So when you do that, you are telling the whole world that, look, this particular contract, we're not taking it for, we're not joking here. We understand the implication of what we are doing, and we intend to create legal relations. So sometimes if you are doing a contract, you might insist that, look, this contract, because of the context of people dealing in this contract, maybe it's a parent company and a subsidiary company, to avoid it being found tomorrow that there was no intention to create legal relations, we are doing this by deed. So we put it there, we write it there clearly inside that this agreement is a deed and it is signed, sealed, and delivered. So that way you ensure that nobody is going to raise objection and say there was no intentions to create legal relations when this contract was entered into. But again, like I said, with the law, that's not the end of the matter. You have a contract, there was offer, there was acceptance, there was consideration, there was intentions to enter legal relation, but the matter does not end there. There's also still a last hurdle you have to cross, which is legal capacity to contract. So not everybody you see has in law the capacity to enter into a contract. And two categories of people you must be very careful with when it comes to entering into contract. Number one, juveniles, that's infants, children, people in Nigeria, under Nigerian law, people below 18 years do not have the capacity to enter into a contract because the law considers them not to have the maturity to understand what a contract requires. But however, with children, it's very dangerous because with children, what happens is that it's not that they are bad from entering into contracts, but the law, has a presumption in their favor. So that presumption is this, that if you enter into a contract with a child, as on your own part, that contract is binding and the child can enforce the contract against you. But on his own side, you cannot enforce the contract against him. So practical example, if you sell electronics, for instance, and a child walks into your shop and buys a PlayStation 5 for maybe 300,000 naira, I don't know how much those things cost now, but let's assume 300,000 naira. And he now says, you know me now, my father, after all, my father is Dangote, I just don't have enough cash here now. So let me give you 100,000. I will balance you the 200,000 next week when my father comes back from his trip. And he gives money to me. And you, of course, you are happy that, Dangote's son is patronizing me. Who am I to insist that he must pay cash? That after his Dangote's son, he won't cheat me. You give him the PS, you collect your 100,000, hoping to get your 200,000 next week. Next week comes, he doesn't pay you. 2 weeks after that, he doesn't pay you. And you're now like, what is happening here? You now decide to go after him and he refuses to pay you, take him to court. Now, he will not be liable to pay you that balance of 200,000 because you cannot enforce the contract against him. So both of you had a valid contract, offer and acceptance was there, consideration was there, there was clear intentions to create legal relations. But because he's a child, you cannot enforce the contract against him. So you can see how funny. But let us flip the coin. Assuming he bought that PlayStation from you and he paid you the full 300,000 and he went back and there was something wrong with the PlayStation and he comes to you and says, Oga, you must change this PlayStation. And you say, look, I won't change it. It was while you were using it in your house that you spoiled it or something, and you're trying to rely on the fact that it was his fault that the PlayStation got spoiled, or it was under his custody, or that he voided the warranty by opening the PlayStation and trying to repair it himself. Now, if he sues you, you can't make the same argument and say, because he's a child, this contract is not binding. He can enforce the contract against you. So if the court finds that indeed he didn't breach the warranty, then you'll be forced to refund his money or give him a new PlayStation and take the defective one back. So you can see that he can enforce against you, you cannot enforce against him. So that's why you have to be careful when you do, if you do a business that involves contracting with children. I mean, in some areas, for instance, in sports betting, for instance, a child is not even allowed to enter into a sports betting contract. So if you run a sports betting company and you don't do your due diligence to find out and the person is a child, then you'll be liable. And like you said, he can enforce against you. So if he wins, for instance, he can enforce against you, or you can't enforce against him. But another set of people that you have to be careful with when you are doing contract with is just like children, people who are not of sound mind, that's people who have some sort of mental incapacity, also have this kind of protection like children. But the exception is that where what you contracted with them is what we call a necessary. Necessaries are, of course, the necessaries of life, food, shelter, and clothing. If the contract you had with them is any of this category, then the contract is valid and binding. So if instead of a PS, what I sold to the child was school uniforms, for instance, then I had basis to sue him and he would be liable to pay me the full value, despite the fact that he's a child. Because in that case, the contract I had with him is for a necessary. So if it's the same thing, if it's food I sold to him, I also can enforce the contract against him. He can also enforce against me. So that's one exception where the incapacity of a child will not affect the validity of the contract, where the contract actually was entered into for the necessaries of life, food, shelter, or clothing. Same also applies where it's a person with mental incapacity. Now, another dangerous set of people you have to be careful with is a person who is under the influence of alcohol. So far as the law is concerned, if a man signs a contract while he was under the influence of alcohol, the law will not enforce that contract against him. That becomes an excuse for him. So he entered into a contract with you to sell you his BMW 7 Series, brand new, that is worth 25 million. I entered the contract to sell it to you for 5 million. I paid him the 5 million. I come to his house the next day to collect the BMW. Now his eyes are cleared. He now says, no, how will I sell my BMW for? Take your 5 million back. I'm not selling. If you take him to court, even though there was offer and acceptance, there was consideration, you paid the 5 million, there was intentions as it were to enter legal relations because both of you sat down and agreed on it. But because at the time you entered that contract, he was drunk, the law will relieve him from the obligation of fulfilling that contract and say, no, how about you, Seth? How do you think you have just gotten a 25 million naira car for 5 million naira? But I mean, of course, if it was clear-eyed, like we said, remember, consideration needs only to be sufficient, not adequate. If he was clear-eyed and he sold you his 25 million naira car, even for 500,000 naira, you get the car and you walk away with it. But the fact that he was drunk as at the time you sold that car makes him not of capacity to contract at that point in time. So practical scenario where this becomes important is how people celebrate signing of contract. So, and there's a practical case where people flew from Japan to, I think Norway, one of the Scandinavian countries, to negotiate and enter into a contract. They flew long trip all the way from Japan, landed, and because of the urgency, they went into the negotiation room straight away, negotiated back and forth. After a hard-fought negotiation, reached a final agreement. The secretary was now sent to go and type up, that agreement and bring back for signing. And because these guys had, were tired and had been in the air and had not eaten at all, they said, fine, okay, while we are waiting for the secretary to get the document typed up, let's move to a bar and just have some refreshments. And because of having refreshments, these guys got drunk. By the time the contract came back and they signed it, they were already quite high. They had, had a lot of drinks and all at the bar. So when the time came to enforce that contract, the Japanese guys were able to argue and say, look, by the time we signed that contract, we were under the influence of alcohol, and there's evidence to show that that contract was signed in a bar. And because of that, they were, that contract was voided, or at least was not enforced against them, because they're able to argue and say, look, some of the things we signed in that contract, our eyes were not clear, we were drunk at that time, we would not have signed them. So what's the practical implication? People sometimes in the course of signing contracts celebrate and decide to pop champagne. So please, before you start popping champagne, ensure that the contract has been fully signed first. Then after that, you can now move to champagne room and start popping champagne. But if you start popping champagne and there's pictures, for instance, to show that while the contract was being signed, a bottle of champagne was next to the person, then he may be able to argue that, look, I was under the influence of alcohol when I signed that contract and it's not binding. So these are just things about contract signing ceremony. Be careful how you do your contract signing ceremony. It's good to take pictures when your contract is being signed. Let it be done in a corporate setting, not in a restaurant, not in a bar, not anywhere where the presumption would arise that one of the parties was under the influence of alcohol when the contract was signed. So I hope we are getting this so far. So we move on to the next. We need to move with some speed. We are kind of behind time. So any questions? I hope we are getting it so far. Any questions? Okay, well, good. So we'll just move on quickly to the essentials, to the factors affecting the enforceability of a contract. So factors affecting the enforceability of a contract. So there are a couple of factors. So like we've said, you already have a binding contract. The contract has offer, it has acceptance, there was consideration, intentions to enter legal relations, and none of the parties had any incapacity. There was no child or a drunk person or anybody who had any incapacity. So you have a binding contract. I'm offering you this bottle of water for 100 naira. You have accepted to pay the 100 naira. You have already paid me the 100 naira. I'm to deliver the bottle of water tomorrow. And I actually deliver it tomorrow. Now, that is the way a proper contract works. But however, some things could affect the enforcement of a contract. So you have a valid contract, it's binding. It's not that it's not binding, but there are some factors affecting whether that contract, whether a judge faced with that contract would actually say, look, this contract should be enforced and award damages, which would explain what happens when when it comes to enforcing a contract. So one of the things that could happen is what we call privity of contract. We'll discuss it some more later, but I'll touch on it a little bit now. Now, I put some funny things. I say meddlesome interloper, or AKA busybody, or AKA third, also known as a third party. So privity of contract simply means that only the parties to a contract, like we mentioned earlier, contract is consensus ad idem, the meeting of the minds of the parties. So only those parties whose minds met and agreed to enter into a contract agreement are bound and can enforce that contract. So a third party cannot come and say, okay, maybe Deborah came to buy this bottle of water from me. We agreed for 100 naira and everything. She has given me the 100 naira. I should deliver the water to her tomorrow. And I refuse to, and I fail to deliver the water. Nnamdi, for instance, cannot wake up and now come and say, Deborah has already paid 100 naira. Why have you not given me a bottle of water? Because I refuse to go at the bottle of water, I will sue you to court for not giving Deborah the bottle of water. If he goes to court, the court will say you are a busybody. What concerns you inside? The contract is between Marx and Deborah. If Deborah has problem or feels that the contract has not been fulfilled, it is her who will come to court to enforce the contract. You, the third party, you are a busybody. This contract is between the two people whose mind met and reached an agreement. You are not involved in the contract. So privity of contract simply means if you are a third party to a contract, you have no right to enforce that contract if there's a breach of that contract. Why this is important is because a lot of times we enter into contracts and there's a third party who is the beneficiary, who is not a party to the contract, but is the one who is to benefit from the contract. So assume, for instance, I enter the contract 100 naira to sell this bottle of water to Deborah, and the person who is going to get the water is Mr. Nnamdi, maybe because she's a caterer, for instance, and she's okay. I think let me see, who was it? I believe it was Gladys who told us that she does corporate events. So assuming Gladys is supposed to, has been given a contract to anchor the AGM of Dangote Industries Limited, and she has now entered into an agreement with me to supply her this bottle of water for the purpose of use at that Dangote AGM. And she has paid me the 100 naira, and I failed to deliver the bottle of water. Because of that, Dangote comes to his AGM and there's no water to drink, and he's angry. And Dangote now comes to sue me and says, because you failed to deliver the water that Gladys paid the 100 naira for, I have no water to drink at our AGM. You can see that the contract was made for the benefit of Dangote, but it was me and Gladys that entered the contract. So Dangote cannot enforce it. So Dangote would have to maybe sue Deborah, Gladys, sorry, and Gladys will now, sue me as well to fulfill that. So you can see how it works, that the fact that you are the beneficiary of a contract does not give you the right to enforce that contract if there is a breach. Like I said, we'll discuss a little bit more about it in lesson 3. Then conditions and warranties. Now we could enter a valid and binding contract, but inside that contract, I can put certain conditions or warranties. Conditions and warranties are not much different from each other. A condition simply is a basis on which is a principal basis on which if it's breached, then the contract becomes void. A warranty is a softer level. I mean, warranty has a different definition in English from contract law. So just understand that this is a different use of the word warranty. So we could make, for instance, a basic condition of the contract, which if that condition is not fulfilled, even if there's a breach of that contract will not be enforced. So typical example, for instance, is your air ticket. You buy an air ticket, there could be a condition there which ties to the next point, exemption clauses. So a lot of times exemption clauses, what we call fine print, fine print, are usually conditions of that contract. So for instance, the exemption clause could state that you lodge into a hotel, and the hotel says, look, you are in the hotel, but in the car park of the hotel, they have put a sign there that says vehicles are parked at owner's risk. That's an exemption clause that says, even though we are taking money from you and agreeing to provide you, give you a room, if your car is parked in our car park and you do not lock it and the car is stolen, we are not taking responsibility for that. That's why our contract is supposed to be that you're supposed to have safety when you come into our hotel, because safety is, of course, one of the bases on which a hospitality contract, I believe it was, who mentioned this in hospitality? I believe that was, I'm trying to see, I know somebody mentioned it was in hospitality, but I didn't seem to have taken that. Okay, hospitality is Nnamdi Chinyere, who told us it's hospitality. So I mean, the basic term of that hospitality is that I expect that if I come to your hotel, I should be secure and all my property and assets should be secure. But in our agreement, we could put it there clearly that one of the conditions is that, look, if you bring any valuables into the hotel, deposit it with the hotel, with the manager at the reception desk, so they put it into the safe. So if you take it into your room, I now complain and say, oh, I brought jewelry which was stolen from my room. Say, well, we had a notice that stated clearly here. Part of the conditions of our contract was that if you have any valuable, declare it and give it to us for safekeeping. So because you do not declare it or give it to us for safekeeping, even though that jewelry was stolen from a room and we should be a breach of contract, that contract will not be enforced, or it will affect the enforcement because that condition exempts the happening of that particular event. Then the next thing is what we call reality of consent. So like we mentioned, and I'll keep drumming in, contract is consensus ad idem, the meeting of the minds. So, but sometimes our minds, we thought our minds met, or we gave consent to something in the contract, but it may turn out not exactly to be what we thought. And this could happen in many ways. One of which is what we call a mistake. So a mistake, again, like I always say, when it comes to law, mistake has the English definition, but in law, mistake might mean, in contract law, for instance, it has a slightly different meaning. So a mistake in law simply means that our two minds genuinely had an intention, but while our minds were coming together, unknown to one of us or both of us, there was something, there was an error in what we thought we were agreeing to. So a mistake, for instance, would mean that when I came, I said, I will sell you the bottle of water for 100 naira. Now, while I was saying I'll sell you the bottle of water for 100 naira, I was holding a bottle. Sorry, the wrapper on this bottle is a little faded. I was holding a bottle of swan water in my hand while I was saying that. And you said, yes, I'll buy the bottle of water for 100 naira. And you give me the 100 naira. Then tomorrow, when the water comes, I now supply you maybe ever water. You now say, no, this is not what we agreed. What we agreed was swan water. So you can see that there was a mistake, because while I was holding a bottle of swan water in my hand, I simply said, I'll sell you a bottle of water. I did not say swan water. And I held the swan water in my hand because I was drinking it, not because I meant this was what I was going to sell to you. So you can see that there was a mistake there. While my mind was saying, I'll sell you a bottle of water, which could be any bottle of water, your own mind was telling you, because you saw me holding swan water in my hand, that it would be swan water. So one area where this plays out in reality is when we call sales through catalogs and brochures. Of course, the popular one now is sales online. So when you are selling products online, the pictures you produce to people must match with what you are going to deliver to them. You can't, that's why it's dangerous to just simply go and pull down anything you see on a website and put it on a website, maybe a tailoring house, like, you know, we always see every day, what I ordered versus what I got. So the person just goes to pull, or you see barbing salon where they show you a picture of Barack Obama, you know, having a haircut in a salon. And I go in there and it's like somebody said that somebody went to have a haircut hoping to look like Drake. And when he came out looking like Sanwo-Olu. So that's a joke. But so the whole idea is that, you know, between what I ordered versus what I got. So as a person who sells, you should be careful what picture you give out. Because if the example I gave now, I was holding a bottle of swan water in my hand saying, I will sell you a bottle of water for 100 naira. And you said yes, and I was doing this way. The law would assume that the way and manner in which I was projecting that bottle of swan water, what I meant when I said a bottle meant actually the swan water. So you could see that despite the fact that we have a binding contract now, the enforcement could be affected by, you know, a mistake made in the mind of one or the two of us while we were reaching that agreement. So that is why clarity is always important. When you have negotiation discussions, go back, reduce it into writing. This is an email. So pursuant to our earlier discussions earlier today, sir, we are glad to enter into a final contract with you for the sale of a bottle of swan water as you described. So that if the person did not mean swan water, you're not clever. Oh, no, I didn't mean swan water. I was only drinking that swan water. I meant I'll give you a bottle of water. The water I intend to give you is ever water. So you can see if there's documentation, you clear out that mistake. So that's why documentation is important. Every time you have a call, even if it's a text message or a WhatsApp chat or an email, better, at least send something back so that there's a documentation trail that clears out any misconceptions in the line of entering into a contract. Another aspect of a reality of consent, you know, where consent was not real in that sense, could also be what we call misrepresentation. So like I put there, the sugar coat he put on it has faded. So caveat emptor. So sometimes misrepresentation simply means that a person gives you a false picture. So you are coming to buy a car and the man says, oh, guy, you see this car? If you carry this car, you enter road now from Abuja to go Lagos. 5 hours, you don't reach Lagos. This car, they run like fire. And then you now buy the car. You now enter the road to go to Lagos. 16 hours after, you are still in the body. You now come back to Abuja and say, you deceived me. You said that this car will take me to Lagos in 5 hours. It took me 17 hours to get to Lagos. And you now sue the man. So you can see that there's a tension there. Now, misrepresentation simply means where a person deceived you. Now, there are two sides to it. Where the information the person gave you is not information that could easily, it's not what we call patent. Patent means something that is obvious on the face of it, that by examination, you can find out by yourself. Where the representation the person gave you is a patent issue. So for instance, somebody is selling you a phone, for instance, and it tells you that, Oga, the phone's camera is this and is that, or the phone has 3 cameras. Now you can simply look at the phone yourself and say, but Oga, I can only see 2 cameras here. there are not 3 cameras. So if he deceived you that the phone has 3 cameras, and maybe he shipped the phone to you, and when the phone reaches you, the phone has only 2 cameras. Now that is a misrepresentation. He has deceived you. But if you had the opportunity of looking at the phone to know whether I had 2 or 3 cameras, and you did not take that time to do that due diligence, then what I wrote there, caveat emptor. Caveat emptor simply means buyer beware. Caveat emptor means in law, you have an obligation as a buyer of goods or services to do your basic due diligence. But however, there's a limit to due diligence. So if the person says the phone has 20 gig RAM and he's selling the phone in a box, I can't open it and check the RAM until I bought it and put a SIM card. Now, a RAM is a latent matter. It's latent. Latent means it's not something I can see on the face of it. A camera is something I can see on the face of it. It's patent. I can see it by looking at it. But a RAM, the RAM, that's the random access, the memory of the phone, is something that I can only see by putting the phone on and examining the phone. So if the misrepresentation is as to something latent, then that would void the contract. But if it is something patent, the law says no. You had the opportunity of, if you did your due diligence, you would have known you had 3 cameras. You have paid the money. You cannot. It was not a breach of contract. The contract is valid and binding. But where the misrepresentation is on a latent issue, something you could not have checked before they completed the contract, then the law would say this contract is not enforceable, is void because the person deceived you on something you could not have known. So that's why due diligence is important. As a business person, you enter into negotiations, always give a room for due diligence. So don't hurry to sign a contract. You have agreed all the terms and all, submit to your lawyer, let your lawyer go and do due diligence. You want to, so for people who say they are real estate, who else told us real estate? I believe the brother told us real estate. So in real estate, due diligence is king. You cannot get into a real estate transaction, a joint venture agreement to develop a land. You have not gone to ages to check if the land is truly valid, or if the person has sold the land, or he has mortgaged the land to a bank, and then you have already given him money. When you move to site, then now somebody comes and burns all your caterpillars on site and says that this land is our own. This man sold the land to us 10 years ago, or the man never owned the land. So due diligence is king. And like I said, due diligence is of course not is not unending. So it doesn't mean that due diligence can solve everything. So if you can show the court that, look, what he deceived me on is something that I could not have found with reasonable due diligence, then you be let off the hook. Then the last of the factors that could affect, from the viewpoint of a reality of consent is what we call duress and undue influence. He didn't give me the choice of refusing. So we know that contract is between 2 parties, but sometimes the parties that enter into a contract could be parties that are of unequal bargaining strength. That means, for instance, a landlord and a tenant. The landlord is the owner of the house. If he says, I'll chase you out of the house today, the man will have to go and sleep on that beggar bridge. So between those 2 people, the landlord now comes and says, I'm increasing my rent today from 1 million to 2 million. And the tenant, is a hard pressed. He accepts just because he has no option. How can I refuse? Or, for instance, an employer and an employee. You say because COVID has come up, because there's a fuel problem and diesel cost has gone up. Or all my employees come and sit down. I'm slashing your salary by half. Sign an agreement. You have agreed hereby to sign salary by half. Now, can it really be said there was a meeting of mind and consensus at Eden? Because if people are not equal, how can their 2 minds even negotiate? Because the man is your employee. What option does he have? If he refuses, you will sack him. So at that point, that's what we call duress and undue influence. That is, the person was not, he was not of his free will. He was under compulsion. So his consent, his consensus at Eden that he brought to the table is not really a consensus at Eden in that sense of it, that his mind, he had no option. You had to force him. He had no choice but to agree that. So in some circumstances, this could also affect the contract that had offer and acceptance, consideration, intention to create legal obligations, and capacity and everything. But because the law says, look, these 2 people are not equal in the eyes of the law, we can't believe that an employee had any free will to negotiate and enter into a contract of his own free will in this circumstance that this agreement came. So sometimes you have to be careful when you enter into transactions or you negotiate contracts with people who are your subordinates. You have to be sure that the contract is even-handed. So sometimes just the fact that, like I always tell clients, the fact that you can negotiate a hard bargain, don't always go for a hard bargain. Always put some things there that will balance the obligation, so that if tomorrow the person goes to court and says, the man forced me beyond my will, you can say, but my lord, I agree that on this clause, it looks like I forced him, but look at the next clause. that also gives him a benefit. So it shows that we negotiated this thing. It was not, I didn't force it down his throat, as it were. And that is why also is avoid what we call contracts of adhesion. Contracts of adhesion are what we call standard form contracts. So that's a contract that is already printed. You simply, a person comes to simply give him that contract. So sometimes you are entering into employment contract with your employees. Each person's contract should not be the same. Because if each person's contract is the same, what it tells the court is that the people did not have the opportunity to negotiate it. But where one person's contract says his leave is 7 days, another person says, okay, in addition to his 7-day leave, he can also take extra leave. It tells the court, okay, that means if another person could have negotiated his own differently, then that the presumption is that in this workspace, people are allowed to negotiate their contract. So that's a way to show that contracts can be enforced. So particularly if you are the superior power in any contract, always learn to be even-handed to avoid giving the impression that that contract was entered under conditions of duress and undue influence. So let me just check. I believe this should be our last slide. Okay. Oh wow, we still have one more slide, so we need to move with some speed so we can before we break. We'll be breaking by 5:30. So so we have 20 more minutes. So like I said, please, any questions or anything you could slow me down. Then the last factor that could affect the enforceability of a contract is what we call illegality. So of course we know the law is legal and the law does not support illegality. So the law cannot be used as an instrument to advance the cause of illegality. So there are two broad types of illegality that could crop up in a contract. One is what we call void contracts. These are contracts that are against public policy. So these are contracts that are on the face binding. Everything, all the elements of a contract are there. But there's a public policy. Public policy is beyond a law. It's not necessarily a law, specific law. But public policy is simply what is thought by in the eyes of the law as necessary for the good of the public, beyond what has been reduced into writing. You shall not kill. If you kill, So there are some other things that affect public. So for instance, public morality, for instance, is also an issue. So a contract, for instance, to run a brothel, for instance, would be considered to be a contract against public policy and would therefore be void. So if a person comes to rent my house, maybe I have a big 10-story building and he comes to rent it, to use it as a brothel, where in addition to not just being a brothel, underage girls are going to be trafficked and brought into that place to carry on the business of a brothel. And I knew, and we signed it clearly, and everything is put there in that contract. And he rents the place for me for 10 million naira. He pays me the first year rent. Second year, he refuses to pay his rent. And I now sue him to pay me the 10 million naira for using my building as a brothel. You see, it's a binding contract. Proper acceptance, everything is there. But for public policy consideration, the law refused to enforce that contract and say, no, this is an immoral, illegal contract, contrary to public policy. The law will not enforce it. Now, this is the obvious way it plays out. But some other subtle ways it could play out, for instance, is what we call contracts in restraint of trade. So, for instance, you are running, I'm trying to see many of our businesses here is very relevant with that. But for instance, you are running contracts that run on personal skill. A barbing salon, for instance, and you have a barber who is very good. And because of him, a lot of your customers have gotten used to him. They know him. When they come to barb, they always prefer to wait on, to be his turn to barb them. And then the guy wakes up, and then of course, in signing your contract with him, you now know that the way this guy, I want to keep this guy. I don't want him to leave me. So you now put what you call a restraint clause in his contract agreement that says, if you leave me, you cannot work in any other barbing salon. Or if you leave me, you can't work in any barbing salon within the vicinity of where our own barbing salon is located. Now, that contract is essentially trying to restrain him from plying his trade. It's valid to an extent, but the public policy is that because the law doesn't want any man to become unemployed to the point where he cannot gain from the work of his hands, the law says, look, if you put that kind of contract, it's valid. I mean, the man is the one who agreed to it, but there must be some measures of control on what you put on it. So, for instance, the contract has to be limited in time and in scope, and maybe in location. So you could say, if you leave me, you can't work in any other barbing salon for 2 years. And for any barbing salon that is within a 1 kilometer radius of our barbing salon, that is limited in scope. The law will enforce that. But when it's a blanket restraint on him that says he cannot work in a barbing salon, the law would void that. That would be a void contract. Now, on the other side, illegal contracts, the example I gave earlier, using, for instance, my hotel, my property as a brothel. Now, because the law criminalizes running brothels, for instance, in the northern part of Nigeria, under the laws, what you call the penal code, which operates in the northern parts of Nigeria, including Abuja. Keeping a brothel, for instance, is a criminal offense. It's a crime to do that. So that's an expressly illegal contract. So you can see that the first example I gave of a void contract, restraining somebody from working is not illegal in that sense, but it is against public policy. But the second category are contracts that are for the purpose of carrying out a crime. So I give a contract, I say I pay you 100,000, go and assassinate somebody for me. That is, that contract. The purpose of that contract is to commit. Okay. So the purpose of that contract is to commit outrightly a crime. That kind of contract, the law will not enforce it. Now, when it comes to illegal contracts, the way the law treats it is that what I put here, away from the judgment seat, I won't be judged over such reprehensible matters. So when you bring an illegal contract before the court, what the court says essentially is that the court will not enforce it on behalf of any of the parties. So if I gave my building to that man to use as a brothel, and he's supposed to pay me 10 million, it doesn't pay me 10 million. When I come to the court refuses to enforce the contract. That means the man will, use my place for free and he won't pay me the 10 million. If the man paid me the 10 million and next month he comes to move in to use it as a brothel and I refuse to allow him in, and he sues me and says, I've already paid him 10 million and he will not allow me to use the place as a brothel, the law will chase both of us away. It means I will keep his 10 million, he won't get his 10 million back. So in a sense, there's a punishment for people who are involved in illegal contracts. The law will not enforce it. So, but one person is going to benefit. So the person who had the benefit on his side. So what it just tells you that sometimes when you enter into contracts now, one area where this plays out is you enter into a contract, for instance, and says a person should pay you a contract sum gross less any tax. And yet the law says that you should collect withholding tax. And you say, look, pay me my money, you go and pay your tax by yourself. Now that contract actually has an illegal element because that contract is defrauding the revenue of tax due to it. So that contract will actually be held to be an illegal contract. And this is a reality of most contracts. So you have to be careful how you put your tax-related clauses in your contracts to avoid your contract becoming illegal. But in any event, if you have to put something that borders on tax, always make sure that the benefit is always on your side, so that if the contract is declared illegal, at least it will be that you are the one who is in a position to benefit. So these are just things you need to understand with how you engineer your contracts and how you manage your contracts. And like I said, we are going to talk about contract management. So I think we're in pole position to finish this section, this first part on time. Then discharge and breach of contract. So again, like I always tell you, in law, words have a different meaning from what they have in general everyday English. So when we talk of discharge of a contract simply means getting parties to a point where parties are freed of further obligations under the contract. So of course, the best way to discharge a contract is by fulfilling the contract. So I and Gladys enter into a contract. I'm selling her this bottle of water for 100 naira. She pays me the 100 naira today. Tomorrow, I deliver the water to her. The contract has been fulfilled, so it is thereby discharged. I have no further obligation to give her another water. She has no obligation to give me any money because we have already performed all that I have to perform under that contract. Now, that is the ideal, but we know that in life, the ideal never happens. But other things could happen that lead to a discharge. That means that free you up from fulfilling your obligations under the contract. So I agree with Gladys to sell her this bottle of water for 100 naira. She's supposed to pay me the money. She says she will pay me the money before 12 midnight today. And that, please, I don't want any delay. Make sure that the bottles of water are delivered to International Conference Center latest by 8 a.m. tomorrow morning. I don't want any excuse. This is for Dangote's AGM. Dangote himself is going to be there. I don't want them to stop their contract with me. And we agreed. We signed our agreement. 12 midnight comes. She doesn't send the money to me. She sends the money to me by 6 a.m. By 8 a.m., I don't deliver the water here. So you can see that I'm discharged from the obligation to deliver that water by 8 a.m. because she also breached her own condition, which was to pay me that money before 12 midnight to make sure that I could mobilize my people, buy diesel, and be ready to deliver the water. So you can see that her breach of the contract has discharged me from fulfilling my own end of the contract. So that's where discharge, where breach of contract and discharge of a contract come to play. So one way you can bring a contract to an end, really, like I said, is to fulfill the contract. The next is that where there's a breach, then you can terminate the contract. You are discharged. So by the fact that she refused to pay me the money by 12 midnight, I can terminate the contract and say, look, I'm not going to deliver the water to you anymore by 8 o'clock because you failed to pay me the money on time. So of course, one way to put a contract to an end is to have the way a contract came into existence by agreement, the contract can also be put to an end by agreement. So I put something from there, I say, okay, let's end it. I'll give you 100 accord, satisfied. So in law, is putting a contract to an end through agreement is what we call accord and satisfaction. So accord simply means we agree for something else to be, used to satisfy that contract. So if we had agreed that I'm going to sell this bottle of water to Gladys for 100 naira, and she's supposed to pay me the money by 12 midnight, and I will deliver the bottles of water by 8 a.m. tomorrow morning, and then she fails to deliver she fails to pay the money on time. She pays me the money late by 6 a.m. and then by 8 a.m. I can say, okay, fine. Since it has before 12 midnight, she now realizes that she has exceeded her bank transaction limits and she will not be able to pay that money until it's at least past midnight when her internet banking would allow her to make further transactions. She can call me by 11 a.m. and say, look, I know we have an agreement where I'm supposed to pay you 100 naira before 12 midnight and you supply me bottles of water by 8 a.m. tomorrow morning. But unfortunately, I can no longer fulfill my part. So can we have a new agreement? And maybe the new agreement is that, okay, fine. Instead of giving you the 100 naira now, I have diesel in my house, 50 liters of diesel. So let me give you the 50 liters of diesel, and then tomorrow morning I would only balance you 20 naira. So you can see that we have entered into a new agreement that has put our earlier agreement to an end. So that's one way to discharge a contract, and also a satisfactory way to discharge a contract, just like performing a contract. Then of course, like I've explained what breach is. So breach is essentially you have failed to keep your part. So therefore I can also fail to keep my part. Then frustration is another strange way that a contract can come to an end. Is closely related to force majeure, but force majeure is a different matter, and I would explain force majeure. But let's start with frustration. So frustration simply means that parties have entered into a contract, but for some reason that is no fault of any of the two parties, the contract has to come to an end, and it's not the fault of any of the two parties. So classic example. I and Gladys has agreed, she's paying me 100 naira, and tomorrow morning I'm going to deliver bottles of water to her to International Conference Center for Dangote's AGM. She pays me the 100 naira by 11 p.m. I mobilize my guys and everything, and they move the water to International Conference Center and deposit it there by 5 a.m. so that even before the 8 a.m. that she said, and then by 6 a.m. there's a fire in International Conference Center and it burns down all the bottles of water I deliver to her. So you can see that that's not a curious situation. The water it's not my fault that the water was not delivered, because the water, or in a sense, the water was even delivered, but she could not use it because the water got burnt. It's not her fault. She didn't set the fire. I didn't set the fire. None of us is necessarily at fault, in that scenario. So when it comes to frustration, it's actually a frustrating matter. So that's permit to use that play on words. Frustration is always a frustrating thing, even for the courts. The courts now wonder who should now bear the brunt. So imagine that Gladys had not paid me the 100 naira yet, and I'd already delivered the water. So she should pay me the 100 naira, despite the fact that she's having to go and buy the water from another person. So sometimes the law finds it difficult to really find a balance between the two parties. So sometimes some judges say, look, okay, pay him 50% of the money so that he bears 50% of the loss, you bear 50% of the loss. But however, know that frustration will not come to play where you should have taken insurance. So where insurance is available and you refuse to take insurance, the law would rule that frustrating event against you. So if, for instance, the frustrating event was that my truck driver who was carrying the car had an accident, and that was why the water could not be delivered, then the question is that, did he have insurance on the vehicle? He didn't have insurance. That is why insurance could not pay. So therefore, I will be held liable to pay her the 100 naira, despite the fact that the contract was not fulfilled. So you understand? So that's why insurance is important. As a business person, you must always, just like we talked about caveat emptor and due diligence, where insurance needs to be in place, make sure insurance is in place. Because if insurance is not in place, you'll not be able to rely on frustration. if it happens. And of course, insurance is also always good because it also helps to, ensure that you don't go bankrupt when a frustrating event happens, even if assuming you are the person who is on the wrong side, maybe the money, your money has not been paid, you have already supplied the goods and the frustration happened. Your insurance would at least be able to pay you a part of your, to be able to cover a part of your liability in that circumstance. So insurance is important to keep as a business person. So force majeure is a different kettle of fish. Now, force majeure simply is a contractual provision that allows a contract to carry on when what would normally have been a frustrating event occurs. So it's a different kettle of fish from frustration. It's a contract mechanism where you are trying to control, the happening of frustrating events and say, look, if an event happens which is outside the course of control of any of the parties, then for the duration that you are not able to control events, you are relieved from the obligation of fulfilling your responsibilities under the contract, provided at the moment that unforeseen or frustrating event stops happening, you go back and continue from where you stopped. So simple example, for people in EPC contracts, you have a contract to build a bridge and there's a flood, or maybe there's heavy downpour and there's a flood and the waters have overflowed the construction site. You have, that's a force majeure event. So typically there are conditions put in the contract that says you have to notify the other party that, oh, there's been a flood, and the waters have not receded, we'll not be able to walk, but we hope that maybe in a week's time, we should be able to control, channel the flood water out, salvage all our equipment and move back to site. So that's what a force majeure does for you. So some people, when they draft a force majeure, in those days, people used to believe God differently from how we believe God now. So in those days, they felt when an event happens outside of the control of man, it must be God's doing. So that's why you see they say acts of God, like rain, storm, tsunami, epidemic. And there's some people used to believe in those days that when those things happen, that it was an act of God. Even though, like I tell them nowadays, when I draft my contract, I'm telling people that very soon I'll be putting in my contract acts of the devil, such as rain, thunder, lightning, strike, and the rest, because I don't believe the God I worship is the one who's going to send a flood on people. So, so for me, very soon I'll start putting that in my contract. But people actually put it like in contract and say acts of God, such as epidemic, pandemic, and the rest. So a force majeure clause is something you must negotiate carefully and ensure. When we talk about contract management, you understand your contract force majeure. The fact that you have a force majeure clause in your contract it doesn't mean you are home and dry. You must ensure that you trigger the necessary steps to enjoy the benefits of that force majeure clause. So if you have to notify the other party, you have to notify him. If you have to, take any steps to ensure that you are able to claim force majeure for the time you're not able to perform your obligations, ensure you do it properly. So to the last lap, even though we are almost out of time for this first segment. So discharge and breach of this should not be, this should be remedies. This should be remedies for breach of contract. Apologies. This last subheading should be remedies for breach of contract. So we have a contract and the contract has been breached. What is now my remedy? What can I get in the law? So the first remedy, of course, is that I'm discharged from further complying. So if I and the borrower had the contract, glad you had the contract, I'm selling you a bottle of water, pay before 12 midnight, and she refuses to pay before 12 midnight, then I have no further obligations under law to deliver that water by 8 a.m. So that's the first thing. You have failed on your part, therefore, I'm no longer going to fulfill my part. So that's my first remedy. I'm relieved of any further obligations under the contract. Then the second type of remedy is what we call a failure of consideration. So refund, please. This is not what we agreed. So where there's a failure of consideration, where the person fails to fulfill, then you are entitled as a remedy to get a refund. So Deborah and Gladys, entered into a contract, supply me. So Deborah, I'm always calling your name. My wife's name is Deborah. So that's why I'm always forgetting and calling your name. So Gladys is the person who is in events. So Gladys have entered into a contract, supply me 100 packs of swan water. I'll pay you 10 million naira before 12 midnight today. Make sure the water is supplied. Latest 8 a.m. tomorrow in International Conference Center. And she transfers the money to me, 10 million naira before 12 midnight. Then tomorrow morning, I now go and supply her one Ijekun bottled water that is produced in Pape and deliver it there. And Dangote comes and sees the water and says, how can they be in Dangote AGM? They are supplying Ijekun water from Pape. Sorry, respect to people who are staying in Pape. There's nothing wrong with Pape. So pardon me for for using that example. But essentially, the idea is that I have breached our contract because what we put in the contract agreement was clear: Swan water, not any other water. So it doesn't matter whether the water is from Pape, even if the water, assuming we contracted for Ijegun water from Pape, and I go and supply Swan water, and I say, hey, but Swan water is of a higher quality, I still breached the agreement because that's not what we agreed on paper. What we agreed was Ijegun water, and I went to supply another type of water. So the moment I breach the contract, now that means there's a failure of consideration, because my consideration, by what you mentioned, consideration, my consideration in the contract was to supply Swan water specific, and I supplied something else. So based on that, she's entitled to get a refund of the money she paid to me. And of course, when we say refund, she's entitled to get a refund, and it doesn't mean I'm entitled to go back and get the Ijegun water. So imagine that the people now, some of the Dangote workers now manage and drank the Ijegun water, others did not drink. So the fact that I'm refunding at 10 million does not mean I'll now insist that all the 100 packs of water must be given back to me. So whatever is left, I can take, even if no water is returned to me, but I'll refund her money in full, because that's not what we agreed. So you have to be careful about this. And that's why in your contracts, always have a refund policy. In your terms of use, your website, if you are doing e-commerce, always have terms of use that make it clear when a person is entitled to a refund and when he's not entitled to a refund. Then the next kind of remedy you can get is damages. So damages is pay for my loss, and then I'll explain what I mean by it's not too remote. I didn't cause that. So damages simply is paying the person an amount of money that will put the person back in the position he would have been if the contract was not breached. So assuming, let me use another type of contract now. Let me use a real estate contract. No, I won't use the product. So let me use Farida for instance. So let me use somebody else was in real estate.
Sorry, Barrister, we're not hearing you anymore.
Oh, so sorry. It's the way my microphone works. My apologies. Once I turn away from the facing the forward, I don't know why my microphone does that. Apologies for that. Yeah, so I'm trying to see somebody else who was in real estate. Okay, so let me use Farida now. So in a real estate contract, I'm trying to demonstrate damages, for instance, now. Now, I and Deborah enter into a contract to sell her a piece of land on Airport Road. She wants to develop an estate. And we agreed for 100 million to sell her that piece of land. And she pays me the 100 million. And the agreement was that I would deliver the land to her in 6 months' time. Maybe I had tenants or some people who were farming on the land. And I said, okay, fine, allow my farmers to harvest their crop and I'll deliver the land to you in 6 months' time. And then within that 6 months, before I deliver the land to her, government suddenly now declares that they are going to build a new centenary city right across the road from that piece of land. And suddenly the land that was just the empty piece of bush somewhere on Airport Road, government has moved in, they started putting up signs, started clearing the road and all. And then that land that I wanted to sell to her for 100 million, suddenly I now see that, because Centenary City is across the road from this land now, this land is now going for 1 billion naira. And I now refuse to sell the land to the Barr. And Octavio now approaches me, I sell the land to Mr. Nelson for 1 billion naira. Now I've breached my contract with Farida because she had already paid me the 100,000 in January. And when June came, I refused to deliver the land to her. I gave it to Nelson for 1 billion. And I said to Farida, come and take your 100 million naira. I've sold the land to another person at a higher price. I've breached our contract because I failed to deliver the land I promised to deliver to her. Now, she has different remedies that she can get from me, but one of the remedies is damages. Now, damages is to put her in the position that she would have been if I did not breach the contract. What is the position she would have been if I did not breach the contract? The position should have been by June is not 100 million, because by June, the value of the land was no longer 100 million. The value of the land in January was 100 million, but by June, the value had become 1 billion. So the damages I'm going to pay to her will now be 1 billion, not 100 million. So you understand how damages work. Damages is not just about the value per se, but it's at the value or if the value as relevant to what the person should have benefited from that transaction that you breached. So I mentioned something about remoteness. So when it comes to damages, the argument always with damages is about whether a particular damage I'm claiming is too remote. So let me give a practical example. Now, the contract between I and Farida to deliver that land on Airport Road to her. When we entered into that contract, the government had not yet declared that place to be a centenary city. But Farida knew that government was going to declare that place to become centenary city. And then Farida quickly rushes because maybe she has somebody who works in government and has insider information that our government is about to do centenary city. Or another practical example that actually happened is railways. Once people are aware where a rail station is going to be, the next thing is to scramble to begin to buy land to build warehouses around there. So having information of where a proposed railway line is going to run through and where the stations will be is actually valuable information that, for somebody in the real estate sector would, give you a head start. So you can quickly rush, meet somebody and say, okay, I want to buy this your land for 100,000. The man say, no, pay me 150. Say, no, okay, no, this is your land. Nothing is happening here. Okay, let me give you 120. You buy it. And then 2 weeks after, they announce a rail station is coming there. The man say, and my neighbors are now selling for 1 million. And I sold mine for 120,000 because I did not know a rail line was coming there. So assuming that by the time I and Farida entered into the contract, I did not know that a rail station was coming there, and perhaps she knew, and we entered into the contract. And before, I knew that the rail station was coming there, and I negotiated and sold the land to her at 300 million, but she didn't know a rail station was coming there. And then by the time the government now decides to cancel the plan to build a rail station there, so suddenly the value of the land is no longer 300 million that we agreed. And Farida sues me and says, no, you must pay me 300 million because this transaction was entered into with view to the rail station coming there. I'll say, well, the fact that the government cancelled the rail station and the value of the land has plunged is a remote consequence. There was no way while we were factoring our negotiation that was the basis on which we negotiated. It's remote, it's not connected to to the basis of our agreement, and therefore your damages arising from the fact that government now cancelled it and you have lost so much money. Your off-takers have refused to pay high value money anymore because the land is no longer what it should be if the railway station was still built there. So essentially, so what we are saying essentially is that that her damages that she was eyeing, they are remote because they were not a consequence directly of that transaction. Then the next kind of remedy that you can get when a person breaches your contract is what we call quantum merui. So that's just a Latin word. Law, we like to use a lot of Latin words because law has a Latin origin. So quantum merui just means pay me a quantum based on the quantum, the amount of work I have already done. So it's not rocket physics, like I say. Pay me for the part of the work that I have done. So for the guys in EPC, so that's I believe who I mentioned they were in EPC. So I'm trying to remember who was in EPC here. I thought I wrote it down. How come I can't see it here?
Yeah, Mr. Stephen and Justina.
Yeah, Stephen. Exactly, and Justina. I wrote it down. I'm surprised I can't see it here anymore. Yeah. So for the people in EPC, for instance, this is something that happens a lot. So EPC, they have all kinds of contracts. They have what we call turnkey contracts, and they have other kinds of contracts that they do. But the idea is that in construction, it could be that the person starts doing the work, he gets to a point and you breach. Maybe you have stopped paying him when the work reached 80%. So you pay him based on what he has done. So there has to be evaluation. I think this work has reached 80%. So the contract was for 100 million, so pay 80 million, which is the quantum of the work that has been done. It's usually very popular in construction sector. Then specific performance is the other side of damages that I mentioned. So sometimes money will not cut it. What you want to buy from the person is not about the money, it's that particular land you want. So maybe there's emotional attachment to that particular piece of land. So you don't want money. So it's not a matter of I've sold the land to Nelson for 1 billion. So okay, no problem. Farida, take 1 billion and go because I've already sold the land to him. So she says, no, it's not the money I want. I want that land because maybe I have a covenant with God that I will buy this land and use it for a particular purpose. So I want that land. So she can go to court and say, look, over my dead body, you must give me that particular land. I don't want any other land. It is that particular I want. The court can give what we call a mandatory order compelling me to give her the land. And if I refuse to do it, the court can order the registrar of the court to sign on my behalf, go to Aegis, and Aegis will issue her a CFO, and she becomes the owner of that person. And of course, ejects Mr. Nelson, goes there and uses bulldozer to pull down all the estates that Octoville has built there and delivers the land to her. So that's what we call specific performance. It is the particular contract I want. I don't want damages. I want exactly what we agreed. Give it that exact thing to me. Then injunction is the last of the remedies that I'll talk about. So injunction simply means telling the person to stop a person from doing something. So for instance, a typical example would be in this land scenario, for instance. So in addition to giving specific performance to Farida to get that land back, the court will give an injunction against Nelson and myself not to enter that land again or to do any further construction on that land, or to pull down every structure there and hand over her land back to you. So an injunction is just a mandatory order from the court telling you to stop and not to take a particular course of action. So I think at this point, we are at the end of phase of lesson 1. We have overshot our time slightly, but let me see from I didn't share the agenda with you. I didn't share the agenda with you, but let me quickly do that, because we are going to have a brief moment for Q&A, and then also for me to run. Sorry, I'm just trying to see. Yeah, so okay, yeah, so we're supposed to go into the next segment immediately, but let me pause here. Let's take at least 5 minutes. Let's take questions and answers before we go to legal documentation. So yeah, let's have questions. And of course, in lieu of questions, I'm also going to be asking questions, but let me take your questions first before I begin to now run a quick Q&A. So questions? Anybody wants clarification? Okay, well, there's a poll already running. Okay. Okay, yeah, excellent. Thank you, Deborah, for posting up our outline. Exactly. So any questions? So we take them before. Okay, so we're going to do the objective test at the end of lesson 2. So any questions before we move to lesson 2, legal documentation? Okay, so maybe we'll just move to lesson 2 and then we'll take questions after lesson 2. So that means, okay, yeah, I guess someone is trying to.
Sorry, thank you very much, Barrister Marx. It's already a lot, and I believe there's a lot of questions. And well, just to encourage the class, if you got lost in the woods, please, it will not be wrong for you to take us back to ask those questions. I know we have a lot of, but please feel free to still raise the question. These are very, very important. Then, Barrister Marx, normally I used to hear a lot about invitation to treat. If you could just light on that. So thank you.
Yeah, thank you very much. So I left that out when I was discussing offer acceptance, counter offer, and all. It should have actually been, sorry, it should be somewhere there. Yeah. So invitation to treat essentially is not an offer, but it's in a sense, unlike offer and counter offer, where I make an offer and you counter me. Invitation to treat is just a special of what I mentioned earlier, which is which is actually drawing you in to be the one to make me an offer. So invitation to treat is not really a valid, it's not a valid offer in itself. It's rather just me trying to tease you to get you to show interest and to be the one to make me an offer. So it's like a counter offer, but rather than being a regular counter offer, which is a response to an offer, it is actually a counter offer that happens first. So it means you cannot accept an invitation to treat. You can only make an offer in return to an invitation to treat, and then the person who made the invitation to treat is the one who now accept your offer. So it's essentially what I also mentioned about how you can control the contracting process to ensure that you are not the one who makes the first offer. You are not the one who makes the first offer, but you are the one who instead invites the person to make you an offer so you can accept or refuse, and that way that puts you in the driver's seat. So I hope, Mr. Nelson, that's okay.
Yeah, the reason why I mentioned it is that as a pharmacist, I found it very, 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 very relevant. And anybody in the retail business would, understand that, for example, when you put price tags on a product, they are invitations, they are not offers in themselves.
They are not offers, exactly. Yeah. So in fact, so practically, what you are saying now is, which is good, is actually a case, a use case now of invitation to treat. So display, for instance, when you sell goods by display, you put price tags or you display items. So the fact that, for instance, maybe the price sticker, price has changed, but somebody, maybe a attendant forgot to change the price on it. So the person cannot now say, no, you must sell to me at 100 naira. What I saw on the counter was that this thing is 100 naira. You cannot tell me that I've reached the till to pay. You cannot now tell me that it's 120. And the man is saying, no, Oga, dollar has increased between last week and now, and we didn't have somebody to change those stickers. But now that you are before me, you are now the one making me the offer to buy it, and I'm telling that no, it's not 100 naira, it is 120. So it's also good to know that. And then, for instance, on your website as an e-commerce, you also put this as part of your terms of use to make it clear that prices are subject to confirmation, and all of that, are subject to other terms and conditions. So that somebody does not say, I saw it on your website and it says 10,000 naira, and now I've come to your shop to buy, you're telling me 12,000, and begins to fight your salespeople. So these are part of the things you should understand about how the contracting process works. So thank you very much, Mr. Nelson, for bringing that. And because of you, I'll make sure I add this now in my slides going forward, because that's actually an important point that I omitted. Thank you.
You're welcome, sir.
Yeah, okay, so Stephen, yes, Amwa Stephen, yes, please carry on.
Good afternoon, sir.
Good afternoon.
Yeah, thank you for your time, sir. I really enjoyed the session. So I have a question for those of us in the EPC industry.
Yes.
I don't know. Is there a way, like, for example, a contract was awarded to you by the government?
Yes.
And you've already started the work.
Yes.
And before you knew it, maybe due to government change or due to your competitors, like maybe your competitor or somebody else that knows people that are very powerful in the government.
Yes.
Now goes for the same contract. The contract was re-awarded to him. Now, I want to ask, is there a provision for something like a real-time contract management system, whereby if I sign a contract with the government, it is going to be real time all over the world. Like, it's going to be very hard to edit out its content, because by the time you take the government to court, the court to tell you, maybe the government to tell you you were not awarded the contract, this and that. Maybe the person has gone behind you to use government forces against you. So there is nothing you can do because the contract was not real time. So is there a provision for a real-time contract management system, sir?
Okay, yeah. Thank you for that question. Yeah, so that, in fact, one of the case studies we are going to do now, we are going to reach one of the case studies when we talk of legal documentation, the next lesson. You'd actually see a live scenario of exactly what you are painting out here. Government gives somebody a contract, and then government changed immediately. El-Rufai came, canceled all the contracts, and the thing turned to fight. And I would also show some of the pitfalls why, for instance, in that case, that contractor lost that case at the Supreme Court. Now, when it comes to contracts, now the first thing to note is that what makes a contract binding is actually the contract itself as signed. So when you go to court, is that contract paper with the signature of the minister or the whoever signed on behalf of government, your own signature there, that is what you use to prove that this contract has been signed. Now, there's an angle where you're coming from, which is now having a real-time unalterable way to track when contracts are entered and all of that. So of course, because arguments may come in court, in this contract, there's a forgery of signature and the rest. So people have, for instance, advocated the use of blockchains to store contracts, to have that kind of real-time, records of contracts that nobody can alter. I mean, that's kind of far-fetched, but even for practical purposes, a lot of things people do to just ensure that their contract is properly notified is having a contract signing ceremony. So that's why you see major contracts signed by government, there'll be contract signing ceremony. You, the contractor, now be the one to take your money and go and buy newspaper space to put there, show picture of Minister of Minister of Housing and Works signing the contract with your company to build 3rd mainland or 4th mainland bridge. You are the one who will drum up all of that, invite AIT, pay them money to come and monitor so that it's there for the whole world to see that the contract was signed, get people to write about it in the newspaper and all of that. So, these are part of the things that savvy business people do. So, I mean, that's why business is beyond just the business itself. You also have to have, even employ what they call the media consultants, who are the people who will be there to help guide to help guide you to make sure that proper publicity is given, for instance, to your contract signing. So as for real-time say technology, there's really none, but with respect to enforcement of contracts, you don't necessarily need that. Once you have a properly signed contract, you are good to go. What some people also do to put extra measure of safety, even though it's not necessary, is to take the contract to court and get it stamped, or take it to a notary public to also stamp. What that does is just to help establish the date the contract was signed. It just shows that okay, this contract was signed, or at least before this period, because the court is a public record where they'll keep a record of your payment you made. So there's evidence to show that, oh, this contract was not backdated, because people can sign a contract and backdate it, but the evidence to show that it was stamped in court or before a notary public may help to establish the date it was done. Also, some other practical tips: when you sign a contract, countersign every page at the bottom, because some of the malpractice people do is that you can sign a contract on the last page. The contract has 10 pages. Page 10 is the signature column where you signed. Page 2 is the part that mentioned that in return for supplying 10,000 cartons of water, you pay 10 million naira. The person can go and remove that page 2, print a new page 2, and change it that he'll pay 8 million naira. So by the time you go to court and he tenders a copy of the contract, he's now reading on page 2 that 8 million naira, not 10 million naira. So, but what you can do to safeguard against that, at the foot of each page, you countersign. So if anybody touches any of the pages, it will show that, oh, something is out of place here. All the other pages are countersigned, only page 2 is not countersigned. It therefore show easily that that page 2 was a forged out, that was inserted into the contract after the contract had been done and signed. So I don't know, Steve, I hope this answers your question, or at least throw some light on it.
Yes, it does, and thank you very much.
Okay, thank you. So I guess for the benefit of time, we'll move to the next. But like Mr. Nelson said, please, at any point, if you need to draw us back, don't feel bad.
I need to ask one quick one. I'm sorry.
Yes, please. Yes, please.
Okay. I want to know if I'm developing a consultancy brief for sponsorship for a client. They're having an event and they want me to say do fundraise for the event. So I want to know, besides having an agreement, the sponsorship or the briefing proposal, the consultancy proposal is different. Then I will have an agreement with them in the terms of our arrangement. Do I need to have an agreement with this proposing corporate or potential corporate that I will be seeking this sponsorship or fundraising from, or I'll be having a tripartite agreement between my client who's having the event and these companies I will be sourcing funds for?
Thank you. So that's an issue of a contract management we'll discuss. But yes, the way it should be done is that there's first of all an agreement or a contract between you and the organization you are helping to do fundraise. So that's a direct agreement that says, in return for helping us do fundraise, any funds you bring in, 5% or whatever, is your commission for helping us raise the funds. So that's between you and them. Then when you go to third parties, you could also just do a direct agreement with the third party and say, come and sponsor this this event that I'm doing for Dangote. In return for doing that, you'll be listed as headline sponsor. Your logo will be put all over the place and all of that. That's also one way. But the better way to do it, I mean, for you as the person in between, this is actually the most beneficial way. You have an agreement with the person doing the event. You have an agreement with the person coming to fund the event. So you are standing between the two of them. So two of them cannot cross over your head, for instance, and circumvent you and now say, leave that lady, what is she talking? Come directly and give us the money. So we don't have to release any 5% to her. But another way to bind everybody's hand to avoid foul play is now what you have said, have a tripartite agreement. So when you get a person who's ready to sponsor the program, I mean, of course, you have the first agreement between you and the company that mandated you to go out and look for sponsors. But once you clinch a sponsor, the sponsor now enters into the second agreement will now be a tripartite agreement between the sponsor, you, and the owner of the event. So that means there'll be two agreements still in this scenario. First agreement between you and the owner of the event that mandated you to go out and look for sponsors. Once you get any sponsor, a second agreement now that you, the sponsor, and the owner of the event. Now, what that does also is that tripartite agreement now allows even the owner of the event and the just like I mentioned about privity of contract, to now have direct relations under that contract. So yes, you should have different layers of contracts, and that's one thing about contracts. Contracts, there's no one will do when it comes to contract. If you need to have 5-6 contracts, please do. Never be shy of having as many contracts as possible to clarify. Because for instance, after you've had a contract with the sponsor, for instance, you might also have been engaged with the person who's doing the media and publicity for the event. So putting that sponsor's logo on the website, or you might need to have another contract with the people who are also doing that. So if you need to have many contracts, have no fear about. Of course, if you can bring everybody under one umbrella and have a multi-party contract where the owner of event signs, sponsor signs, you sign, the media company is going to do signs, everybody signs, it's also fine. But sometimes having too many parties in one contract creates problems. So it's better to keep contracts separate just to avoid, where there's now a conflict of obligations, and suddenly you now find that, for instance, that some of the obligations in another contract, there's no opposing consideration moving. So sometimes it's safer to just have different agreements with all the different parties. And when we talk about some of what we are talking in lesson 2 now, you begin to see why this is actually a practical issue. But I hope that answers the question.
Thank you, Sama.
Okay, thank you. Okay, so we jump into lesson 2. Wow, so we have to try and do this in 30 minutes, but I believe we should be able to, because lesson 2, is it one slide? Let me see, let me just be sure. Okay, lesson 2 has 2 slides. Okay, so I think we should be able to get it done. Is it 2 or okay? Okay, yeah, lesson 2 has 2 slides. Yes, yeah. So talking of legal documentation, so essentially legal documentation we're just trying to discuss a few of the very common legal documents you would come across in running your business. Now, the first of them is what we call the Memorandum of Understanding. Sometimes it's called letters of intent. Sometimes it's called Memorandum of Agreement. It can be called a lot of names. Now, the first thing to note about legal documentation is that always be careful with legal documentation. The way we say it in legal documentation is that the fact that it is tomato paste written on a can does not automatically mean that if somebody pours sand inside, that sand becomes tomato paste. So the name that a contract document bears is not necessarily definitive of what that contract document is. So it could be on the head of the document, could be written Memorandum of Understanding. But when you read inside, it's a joint venture agreement, or it could be something else. So the name is not always what matters. So when we mention names of documents, don't let the name is just a convenient way to try to describe what the principles governing that particular legal document can be. But what is the content of the document is what matters, not the name that has been given to the document. So that's why I say you could see MOU, letter of or LOI, letter of intent, or MOA, Memorandum of Agreement. They all largely mean the same thing. Now, these are documents that are entered. They are what we call an agreement to agree. So you enter into these agreements at the preliminary stage because you might not have scoped out the clear course of the transaction yet, but parties need to begin to take steps towards the agreement. So sometimes you do this, okay. Oh, sorry, I see a question. Okay, okay, I'll take the question at the general Q&A. I see a question from Ifeoma. So I'll take it at the general, when we take general questions at the end of this segment. Thank you for the question. So these documents are documents that you enter into when maybe the scope of the transaction is not clear yet, but parties are already beginning to transact. So you just want to have something to show what the intention of the mind is and where you are headed. Now, ordinarily, they are not considered to be legally binding because at that point, there's no clear cut where this transaction is headed. So it's just to document what our understanding is so far. So for instance, I want to enter into an agreement to start up maybe, for instance, a retail pharmaceutical, and he has a pharmaceutical plant, or maybe I have a pharmaceutical plant. He's a retail pharmacist, and he wants to become my distributor, maybe in the South, for instance, and I have the plant, or I'm a large-scale wholesale importer of pharmaceuticals products from India, which is usually the pharma industry, and we are looking at the possibility of launching a certain type of drug in the South, but there are a lot of things we need to still understand. For instance, what is the shelf life of that product in the high humidity terrain of the Southeast and some other kinds of factors. I am sure this doesn't play in pharma because pharma is usually standardized when it comes to shelf life and all of that. So I don't think this will exactly be relevant example, but let's just assume that was a consideration. Now, some things have to be done. He has to study the market. He has to put together a business plan. We need to even know what is the size of the market in the South. How many of these products, so that we even know what minimum quantity order we are going to impose on him when we enter the distribution agreement. But while we are doing all that, he's going to be spending some money to do that. So we can enter into the memorandum and say, we are hoping to enter into an agreement where you'll be buying not less than 10,000 units of these drugs per month. And then based on that, you need to go to the market, do some scoping, do some analysis, some of the things you have already been put through in this course to know what the size of the market is, so that we can now enter into a retailership or a distributorship agreement that will now have binding terms. So at that point, we are not sure what we want exactly yet. We don't even know how much we are going to price the goods yet, because we don't know what the buying capacity in the South is, what the packaging should be. Should we give 100 milligram dosage, or should we pack it in a pack that have 6 sachets, or should we sell 1 sachet so that we can sell at 200 naira, all those kinds of thoughts. So at that point, we enter into an MOU that will allow him go and explore the market and do some more research and analysis and come back. Then based on that, we can now enter into a binding agreement. So typically, an MOU should be followed with a more substantive or definitive contract. So maybe an MOU and then later a distribution agreement or a joint venture agreement or some other kind of agreement. So it's used as a roadmap to guide negotiation and other pre-contract issues. So it's not exactly binding. Now there's a Nigerian case that typifies this, like I was discussing when I mentioned just now that I was going to give a case scenario, a very heartbreaking case, and it's a live case. If you are in Abuja, you know something about it. Now, what happened in that case was that the government decided that they will not be able to develop all the districts of Abuja by themselves. So they thought of, look, let us enter into a PPP, public-private partnership model, where we allow somebody come, develop all the infrastructure in the district, all the roads, do the, all the sewage, power and everything. And in return, instead of paying you cash, we'll give you maybe 25% of the plots of land that come out in that district as your payment, like a land swap kind of deal. So government entered into this transaction before the El-Rufai administration with a company for Ikongbeh district. So if you know Ikongbeh, where Gishiri village is, which is right till now, that place doesn't have infrastructure till now. They entered into that contract, and it was an MOU that was signed essentially. Based on that MOU, the company went to town, bought caterpillars, started, got surveyors, started doing some scoping, began to do some preliminary clearing to have an idea of, how the roads should work, and design, and spent a lot of money doing all of that. Shortly after, then government changed. The new government came, revoked the contract, and tried to enter into an agreement with another company. So that company that has spent so much money sued them. The case went to the FCT High Court. FCT High Court said, I think FCT High Court found that government was liable, awarded damages to that company. Government appealed, Court of Appeal. Court of Appeal, I think, also agreed, or I can't remember exactly now, but it now ultimately wound up in Supreme Court. Supreme Court said no, that company, has no basis, because what they had and signed the government was an MOU, and an MOU is not binding. Under that MOU, there was nowhere where it gave them the MOU had not even set the price, had not set any of these parameters for a binding contract, so therefore it wasn't binding. So any money they spent was their loss. I mean, it was them who, in their eagerness and anxiety to prove their capacity, went out of their way to spend so much money, but that was how that company lost out completely. So this is a huge lesson that you must learn. Be very careful when you sign contracts. And if you must sign an MOU, then put in the MOU clear that even though this MOU is not binding, any expenses made for purpose of getting further information or scoping, or you can state specifically. So for instance, in the contract Nnamdi now, Nnamdi will state clearly that, look, any money I expend by way of doing research and market analysis in the South, if the contract does not go ahead, I'll be reimbursed, so that way you have a basis to sue, at least to get a reimbursement on that head. So be careful with MOUs. They are useful. They are necessary to at least get parties around the table to clarify doubt, so that you don't have misrepresentation. So it is clear with the MOU where we are headed, guide our negotiations and all, and that way you are sure that you are headed somewhere with your negotiations. But just be sure that before you begin to spend money and before you begin to take steps that are part of the contract, that either a binding contract has been signed or you have made sure that MOU has covered, allowing you make those expenses to get something back. So then the next kind of legal documentation you hear, for people in the fintech, people like Richard, Jeremiah, this would be of interest to you, and I'm sure it's something you'd have seen at play. is what we call a term sheet. Is what we call a term sheet. Okay, I've seen on that question. We'll take it at the Q&A session. So a term sheet is like an MOU, a letter of intent. The difference with a term sheet is just that it's usually done in more like a bullet point. It's not written like a full length. It's usually maybe a 1 or 2 pager, just a bullet point of some of the some of the relevant terms that material terms and conditions, of a potential business agreement, establishing the basis for future negotiations between the parties to that transaction. Is essentially like an MOU. There isn't much difference. Just like I said, it's just that the format looks different. It's usually done like a bullet point document, sometimes even a table. It could even be done like a table, just simple write-up. However, note that there are some industries where a term sheet has become a specific type of binding document. So, for instance, in the funding space for fintech, so if in venture capital space now, if you hear the word term sheet, don't assume that it's like other areas where it's just like an MOU. A term sheet has become a standard agreement that is known to be a binding document in the financing, private equity and venture capital space. So fintechs and all know, this is a special kind of document, and it's usually binding because it's usually very specific and definitive. It makes it clear how much the investor is investing into your business, what control he has over the board, how he's going to exit, how there's going to be valuation and pricing at his exit point, and many other terms and conditions of that investment are usually embedded in that agreement. Then the next agreement I also look at is a joint venture agreement. It's a very common type of agreement. So it's simply when two ventures or two businesses come together to carry on a separate kind of business. So it's beyond just two people. A partnership is where two human beings come together to carry on a business. A joint venture is where two businesses, not just two human beings, but two existing businesses come together to carry on another venture, and usually incorporate what we call a special purpose vehicle company. So a special purpose vehicle company is just a company incorporated by two other existing businesses to pursue a particular line of business, not a general nature company, but especially for a particular purpose to help them, maybe sometimes in EPC contracts, for instance, to bid as a consortium. So maybe two companies come together to bid, to put in one bid as a consortium. That's one way you'd see joint ventures play out. So of course, in joint ventures, always be careful to be sure that you are bringing something to the table. So if you are not sure you are bringing something to the table, remember when we mentioned about consideration, if you are not sure you are bringing something to the table, then put a nominal figure there. Say in return for the sum of 1,000 naira or 1 million naira, we enter into this agreement to jointly bid for this, and we share this way and the rest. So that way, even if your counterparty now argues to know that after you didn't bring anything to the table, you can share the, well, I paid 10,000 naira, I paid 1 million naira, or even I paid even 10 naira is good enough. You might consider putting a nominal consideration in that agreement just to be sure that your own obligations there under that agreement are binding. Then, of course, joint venture agreements are an excellent tool for cross-border collaboration. So typically when a foreign company comes into Nigeria, we're going to discuss a little bit more about that, I think, in the last segment. When a foreign company comes into Nigeria and wants to do business with you, one of the ways to achieve that is to incorporate a joint venture company, or to sign a joint venture agreement, and possibly go ahead to incorporate a joint venture company. So now, when it comes to joint ventures, there's what we call incorporated joint ventures and unincorporated joint ventures. So an incorporated joint venture is where you have established or incorporated a special purpose vehicle, carry on that joint venture business of the two ventures, where you simply run your joint venture under an agreement and you don't incorporate a new company, you just have an agreement. So for instance, maybe my company owns land, Octoville wants to develop an estate, and we enter into a joint venture without incorporating a new company to carry on that estate development, then that is what we call an unincorporated joint venture. So for instance, in the Nigerian oil and gas sector, that's one of the predominant business models used. So there's the joint venture model is one of them. There's a production sharing contract is another kind of model, business model used in the oil and gas sector. But joint ventures are powerful tools. I mean, if you're a business person, it's almost something you would definitely encounter, because you're always going to want maybe economics of scale to join forces to another existing business to be able to scale up quickly or to enter into new territories and operate there. And that business already has local expertise. So you simply leverage on by setting up a joint venture, either incorporated or unincorporated. So we move on to another type of agreement you will see exclusivity agreements, sole distributorships. So it's a so I say sole distributorship, so importer, exporter, pure water. You know, it used to be very popular in those days. One of the quickest way to make money in those days, just become the sole distributor of a company. When, you know, for any emerging economy, it's an easy way to make money. Just become the sole importer. For import-dependent countries like Nigeria, become the sole importer of any product that Nigerians will need, and it just means that you can just fall into money overnight. It's also quite a good model. Distributorships, like we mentioned in the scenario of I and Nnamdi, for instance, in retail pharma. So I'm producing my pharmaceutical products. I give him an exclusive agreement to become my sole distributor in Rivers State, or become my exclusive distributor in the South or in Northern Nigeria, or depending on how we want to negotiate it. Now, some of the things that you must take care of when you negotiate an exclusivity agreement is you must define the territory properly. So what territory is this agreement covering? It must be stated very clearly. You can't just say the southern parts of Nigeria. Southern parts of Nigeria can be misleading. What are the southern parts of Nigeria can become the subject of argument. The person could argue and say, no, southern parts of Nigeria means only south-south. Say, no, southern part of Nigeria means south, southeast, and southwest. Somebody say, no, western part of Nigeria is western. Southern part of Nigeria means south, and southeast put together. And also sometimes you need to define it, mention the geographic location. For instance, I did a distribution agreement recently, and we had to do something because from an earlier experience, we gave somebody exclusive distributorship in Abuja, and the person was now selling the products in Nyanya and in Maraba. Now, the person who had the exclusive distributorship in Nasarawa was now offended because for him, the biggest market for him was actually the Maraba market. So the fact that we did not delineate clearly. So in fact, because of that, I now learned the real boundary between Abuja and Nasarawa, and it was not even that boundary. We see there's a peg. If you are going, if you know Nyanya Road, if you are going somewhere on that road, there's one place where they put some long pillars and they claim that as a boundary. We now found out that's not even really the boundary between Abuja and Nasarawa. So you need to define very clearly what is the boundary. How do you border towns like Lagos, for instance, where from Bega or Jodu is now Ogun State, but yet is part of Lagos City. You need to define and clarify those boundaries clearly. Same thing with Abuja, Zuba, Suleja, and Madala. You need to clarify and make it clear what the boundaries are. Then, of course, in every exclusive distribution agreement, if you are the person who is giving out the product, you certainly want your distributor to sell as much as possible. If you are the distributor, you also want to sell as much as possible. You want to be careful not to overstock. So minimum order clause is a very important element of exclusivity agreements, where you now have to negotiate it carefully. So that's why you need to do your market researches and be sure how much is my market. How much can my market really carry? So me and Nnamdi will not want to now come and make promise and say, oh, my South is very large. Give me 1 million units every month, because once you put that minimum order, it means that he must buy 1 million every month. So if you now buy 1 million every month and you cannot sell it, you're lost. Too bad. Next month you must buy another 1 million as well. So you want to negotiate your minimum order clause to be realistic. You may even want to tweak it to say, look, okay, in certain months, the minimum order should be allowed to drop. Or even if I fail to meet the minimum order in certain months, I should be given the grace of 2 or 3 months to make it up before it can be called in as a breach of that clause. Then one interesting business model that can come under exclusivity is what we call franchising or business formatting. So it's simply saying, do as I do and do as I say precisely. So unlike an exclusive or the regular sole distributorship or exclusivity agreements, in franchising, what you are giving to the person is not just products. You are giving him a full business format, a full business model. So sometimes you include things like uniform, accounting system, furniture that's going to be used for the business. So typical example where this happens is in eateries. So if you go to, for instance, even before Mr. Biggs folded up, even though I heard there's still one Mr. Biggs outlet open, I have not seen a Mr. Biggs outlet in a long time. But even before Mr. Biggs packed up, if you go to Mr. Biggs, what you are seeing is Mr. Biggs, but the real business running is not Mr. Biggs. It could be Marx Ikongbeh Limited, who has a franchise for Mr. Biggs in Garki 2. Somebody has the franchise, but we all have to use the same format, same paint, same color, same brand, same look, same feel, same uniform attire for the staff, same accounting system, same furniture, same everything, has to be the same. Because the idea of franchising or business formatting is that you want to extend exactly the same business operations to as many people as you can, using other people who just come in, buy your exact business model, including everything using the business, and they just replicate exactly the same thing in the same way. So one important thing about franchising is that in the agreements in franchising, there's what we call policing. So sometimes there's what we call a master franchisor. So KFC, for instance, has a master franchisor. So that's the first person who brought the KFC franchise into Nigeria. So he acts as an agent of KFC to police the other KFC franchises in Nigeria to make sure that they are keeping strictly to the terms and they are dealing exactly. And then also with franchising, there's also the franchise fee, which is very important, because the franchisor simply tells you, that's the owner of the franchise, says that, look, every month before we start talking of sharing profit, you must give me $25,000 first. Then after $25,000, from your remaining profit, I take X percentage. So that's like a minimum order. That's it just works like a minimum order in franchising. So these are things that have to be negotiated very carefully to ensure that you don't run at a loss. However, there's a final note here that is almost a sad note. Under the new Federal Competition and Consumer Protection Act passed in 2018, exclusivity agreements, sole distributorships, are no longer valued under Nigerian law. There's still a window, there's still a way you can do it. So we still manage to craft and engineer and do some legal engineering to be able to craft exclusivity agreements and franchises. But under strict Nigerian law, if you read the law the way it is written, you can no longer give anybody an exclusive agreement that is exclusive to geographic location and that controls the prices. So, and the reason why the Federal Competition Law says that is that those kinds of business models have the capacity to distort the market and to create monopolies and cartels. So monopolies simply is one enterprise being dominant in the market beyond a certain percentage threshold of the market. A cartel is where different organizations come together and are using price and other mechanisms to control and manipulate the market. So it is viewed that exclusivity agreements and so distributorships have the tendency to do this. So, but there's, like I said, there's a way of legal engineering that is possible to still craft this without breaching the law. But for those ones, you will have to come to my office and pay some money before you can get that wisdom. So then the last kind of agreement we want to look at is also an agreement that plays in the funding space. So people in the fintech space, startups and private equity and venture capital, this is also one of the staples of that industry. Oh, Gladys, sorry. Wow, sorry about that. So simple agreement for future equity, SAFE, is a special type of agreement that is essentially a funding agreement. Now, I won't go into the technicalities, I'll just describe it on the surface. But when we talk about in our last lesson, maybe I'll try to raise it up in our last lesson and see if we go into it a little bit more, since I know it will be quite relevant to you. So SAFE is an agreement between an investor and a startup company, where the investor contributes a certain amount of money to the company to enable it to take off or to run its early stage operations. The funds are not given in return directly for equity at the time of investment or contribution, but it provides a right for the investor to get equity in the future. So if, for instance, the company becomes successful, the company goes public or is about to sell shares to other people, then at that point, the company is forced to now give a certain number of shares to that investor based on certain criteria that are already predetermined, the way the shares will be calculated based on the money he has given before. So why this is a very useful tool is that it is a non-recourse type of funding where the investor is, in a sense, acting like what we call an angel investor. The person who is giving money on faith that if the business succeeds, he makes a return. If the business fails, then he cuts his losses and he walks away. So to a large extent, the SAFE operates in, I would say, it's a safe way to fund startups so that they are not under pressure of loan, or they are not under pressure of people coming to sit on their board and then there begins to be infighting and all of that. So it's a good middle ground and a good way to fund startup business. So I believe I think I wrote on. Otherwise, it's hard for me to find. Okay, so Wonder Gold, Chine said this in MSME. So SAFE, for instance, is a very good way to encourage MSMEs and to encourage startups and help them grow and scale. So I think at this point, we have come to the end of lesson 2. So there are already some questions posed. So we have good time. We're supposed to end lesson 2 by 6:30. So that means it will give me time to answer those questions. and then we can do some of our Q&A before we go on a brief 10 minutes break. So let me start by answering the questions already posed, and if there are more questions, you can raise them. Let me answer the questions already posed from the Q&A box. So I'm trying to see where the questions. Okay, yeah. So Ifeoma ask. Okay, so Ifeoma ask. I want to ask, sir, under privity of a contract, a student rents a house in school, and probably some of the facilities contained in the agreement is found not to be on ground after moving into the house. Can the student's parents who files to sue the landlord refer to as a meddlesome interloper? Yes, if the student is above 18 years, yes, there will be meddlesome interlopers, because that's why it's them that paid the money for the house, but the contract is entered in between the student and the landlord. So the parents cannot fly over the student except the student is below 18 years. So even the student is below 18 years, they will sue as what we call next of the next friend or guardian of the. So that's how children sue. So when a child is suing, you say something like, so if I was a child, for instance, you now be Max Ikongbeh suing through his guardian or suing through his next friend, Nelson O'Connor, who is going to be the adult or the parent who is suing on his behalf. So in this scenario, the parents will be meddlesome interlopers except the child is a minor or the child is a minor, then the parents cannot sue. There would be meddlesome interloper. Then Daniel Udemezwe asked, please, at what level does an agreement become binding, e.g. deed of assignment? Is it after the parties sign or after the lawyer seal it or after it has been notarized? Excellent, fantastic question. Yeah, so when it comes to an agreement actually becomes binding the moment the parties have an agreement and manifest a clear intention. So sometimes, even before you sign an agreement becomes binding. Typical example. Now, I and Gladys have entered into a contract that I'm supposed to supply 100 bottles of this water to ICC. She has an event she's going to do, and she's supposed to pay me 100,000 for that. Now, she's supposed to pay me that 100,000, but she fails to pay the 100,000. But I've already moved my truck, moved the water, and delivered the water. At that point, even if we have not signed the agreement, maybe I send the agreement to her via email and she has not signed it, but I've already fulfilled the agreement by delivering the water. That agreement has already become binding, even though it has not yet been signed. So there's actually a case where it was MTN Nigeria versus a company. They had an agreement. The agreement wasn't signed, but the company had already gone ahead to start fulfilling that agreement. MTN now later defaulted. I wanted to terminate, and then the court said, no, you can't terminate. The guys have already fulfilled the contract. So even though there was no signed agreement, it had already become binding. So an agreement becomes binding the moment parties have, there's a meeting of the mind of the parties, and one of the parties has already fulfilled the conditions of that agreement. Of course, ideally, and that is why when important, thank you for asking this question now, there's something I left out. When you do business communication, and it should have been part of this course, I think I omitted it. When you do business communication, there's what we call subject to contract. When you write a person a letter, you write on top of it subject to contract. Subject to contract means that even though in that document you have made an offer to the person, you want to avoid that offer becoming a binding contract until parties have sat down and signed the contract. So you write on the head of it subject to contract. So for people in the real estate space, for instance, when we give letters of offer to a tenant who wants to rent a house, now we write there subject to contract. So we state it clearly, we'll rent this house to you at this amount and this amount and this amount. However, it is subject to us entering into a tenancy agreement. So until that tenancy agreement is signed, even though you have paid and you have moved in, there's still no binding contract. So those are the ways to ensure that your contract does not become binding before you have signed it. So you need to put those clauses very clear. So as for lawyers sealing it or notarizing it, those things are irrelevant to the bindingness of a contract. Technically, those things could only help to show that the contract was duly entered, that there was no undue duress. So there's what we call, for instance, illiterate jurat. So if you're entering into a contract with an illiterate, there must be a column that states clear that somebody had explained this contract to the illiterate and that he understood it. Maybe the man doesn't understand English, that the contract was translated from English to Hausa and he understood it before he signed. So that is when things like lawyer seal and notarization may become important, but normally they are not important. What is important is that parties signed it or parties have already fulfilled. Second question from Daniel Demezwe, are verbal or gentleman agreement binding? No, verbal or gentleman agreement are not binding. They're only binding in honor. So the person decides to be dishonorable and not to fulfill it. It's not binding. That is why in business, do not use verbal or gentleman's agreement. Always find a way to reduce your agreement into writing. However, a gentleman's agreement that now involves a step you should take, and you take that step, like the example we give now. If I and Gladys had a gentleman's agreement, supply this water, I'll pay you 100,000. I'll later sign and send an invoice to you and sign it. And before she sends the invoice, as a gentleman, I fulfill my condition, then it will be binding, even though it is a gentleman's agreement. So you can see fulfilling a contract is always a way to put a signature on a contract that makes it work and becomes binding immediately. So even a gentleman's agreement where I fulfill would become binding. Then the third question from Daniel Demezwe: what is required for land acquisition? Is it deed of assignment, land purchase agreement, MOU? Excellent question. Now, when it comes to land, by law, land in Nigeria, as far as Nigerian law is concerned, technically, nobody has ownership of land. All lands in Nigeria are owned by the state governors where those lands are located. The state governors grant what we call a right of occupancy to people to use the land for 99 years, or depending, some maybe less than 99 years. So technically, we are all tenants of the government when it comes to land. So because of that, the highest interest that you have in land is a right to occupy the land and put developments there and enjoy it. So therefore, when you are selling the land to a person, the interest you are giving the person, that you are assigning your interest, which is a right of occupancy in that land, to him. That is why we call it a deed of assignment. So the document that transfers complete ownership of land in Nigeria is called a deed of assignment. Some people call it a deed of conveyance. Like I say in law, the name is not what matters. So the fact that tomato paste is written on is not our problem. It's what is actually inside. Is it sand or is it tomato? So some people call it deed of conveyance. It's fine. Some people even call it MOU. Some people call it land purchase agreement. Some people call it anything. No problem. It's fine. Any name you call it, provided inside the document states clear that I hereby assign the unexpired residue of my right of occupancy in this land to Mr. Nelson. That's all that matters. Once you have stated that clearly, if you have stated that clearly, then you know that qualifies as a deed of assignment. Now, one common misconception, people who are in the real estate sector now, let me help you. They sell land using what we call power of attorney. Now, power of attorney cannot be used to sell land. A power of attorney is simply an instrument, a document that appoints another person to act as your attorney. An attorney simply means a person who can act in my stead, who can act on my behalf as my delegate. So a power of attorney is just simply a way you delegate power to a person to do something. Now, however, why people use power of attorney to sell land is because of the nature of the Land Use Act. Like I've told you now, the Land Use Act says that all land belongs to the state government, state governor, who holds it in trust on behalf of Nigerians, who is able to now give right of occupancy to people. So by the Land Use Act, for you to transfer your right in interest from one person to another, you must get what they call the consent of the governor. So the governor must agree to that transfer of title, because the land is his own. So he cannot transfer his land to another person without his agreement. So sometimes getting that consent can take a long time. So to avoid long story, what we do, the best practice is that when you sell land, there are 3 documents you should have. A contract for sale of land. A contract for sale of land simply is the contract that governs how parties reach an agreement to sell the land, how much you will pay, what is involved in the land. For instance, if the land has a building already, all those things should be put in the contract for sale. Usually the contract for sale should be done in advance when parties have negotiated and even before due diligence is done. Then, and the contract now state that, okay, in that contract you state clear that, okay, look, you give the person 1 week to do due diligence. After that 1 week, he can pay the money, and when he pays the money, a deed of assignment to be signed on his behalf. Now, but however, like I said, because that deed of assignment, getting it registered may take a while. So the C of O for that land will still carry the name of Mr. Nelson, who sold it to me. So if I need to go to court, remember privity of contract. If somebody now encroaches on the land and I now sue, they'll say, "Oga, you are a third party and an interloper. Mr. Nelson is the owner of this land. He's the one who is supposed to sue. And maybe Mr. Nelson has sold that land to me and has traveled. He can't come." So to give me that interim measure, pending when the governor will agree to the exchange of land between me and Mr. Nelson and issue a C of O in my name, we'll now also do a power of attorney. So that power of attorney now says that Mr. Nelson has hereby delegated me to exercise every power that he has over that land, including the power to go to court to sue anybody. So that if I go to court, I will now sue first defendant. I can sue in my name and say Max Ikongbeh, suing as agent of, Mr. Nelson Okona, suing through his lawful attorney, Max Ikongbeh. So that authorizes me, that power of attorney authorizes me to sue on his behalf. If government decides to acquire that land and wants to pay compensation, I'll take that power of attorney and go there and say, their compensation is supposed to pay to Mr. Nelson. He has authorized me to collect on his behalf by this power of attorney. You also, so the power of attorney is a document that stands in the interim to make sure that you are able to exercise all the powers of the owner of that land, pending when government recognizes you as the new owner of the land. Then, of course, the last document is the deed of assignment. So these are 3 documents. If you're in the real estate sector, ensure you always have those 3 documents when you are buying land at any point in time. Otherwise, your purchase of land would be an issue. Okay. Oh, sorry. I'm seeing Gladys and her challenge with power. Bele for this our Nigerian trouble. Okay, then Stephen Chinedu says, sir, would you mind shedding more light on the gentleman agreement? Thank you. Yeah. So, like I mentioned, the gentleman agreement simply is, people just have a discussion and they believe that each person will fulfill it based on trust. So, and honor. So, therefore, there's no need to reduce it into writing. That's the gentleman's agreement, essentially. That, look, I believe you're a person of integrity. If you have promised me you are going to sell me this car, once you come back, I've sent the 25 million to you. Once you come back, you deliver the car to me in 2 weeks' time. No written document anywhere. So that's a gentleman's agreement. Like we say, with the gentleman's agreement, if anything goes wrong, it becomes difficult to enforce it because, number one, it becomes my word against your word. I say, no, we never discussed that. So the person has become a dishonorable person. So that's why gentleman's agreement is dangerous. Reduce it into writing. Even if it's a text message, send to the person. Say, thank you, sir. Pursuant to our discussion today and our agreement to sell the car, I really appreciate you and I thank you for being a person of honor and integrity. I just confirm that I will make the payment of 5 million as agreed on Friday and I will pick up the car next week, Friday. That way you have not taken out of the realm of gentleman's agreement. There's not a written document, even if it's just a simple text message, to evidence the fact that parties entered into a contract. So please, in business, I beg, don't rely on gentleman's agreement, please. Do all your contracts, let them be proper agreements and formal contracts, leave gentleman matter. Okay, and then final question from Amua Stephen, are these documents necessary? Governor's consent, deed of assignment during land purchase, absolutely important. So in part, that's part of what we call due diligence. When you get a lot of due diligence for land, these are things he's checking. So I'm buying a land from Mr. Nelson to do an estate. Stephen is coming to buy that land from me. And then my Stephen's lawyer now needs to do due diligence. So he needs to come and check first. How did Max become the owner of this land? Max bought it from Nelson. He doesn't stop there. How did Nelson become the owner? He now says that Nelson bought it from Farida. So he has to now check between the sale between Nelson and Farida. Did the governor give his consent? Governor did not give his consent. Wrong for your dear life. Or governor, gave his consent. Then you confirm that that consent, was validly given. So this is part of what due diligence is all about. You need to check all this because when it comes to land, land is when it comes to title of land, caveat emptor, like I mentioned during misorientation, means that you have a duty. Land title is a patent matter. It's not something that is hidden. So if you don't do your duty, don't come and say tomorrow that, oh, I didn't know that they didn't do governor's consent. Then that's your headache because you should have done that. It's a patent matter. It's something that anybody who is a business person knows that you should do due diligence before you buy land. So a court will not have mercy on you that you fail to do due diligence when you're buying land on title of the land. But if it's due diligence on something, for instance, an unknown factor, like maybe the land has something running under it. For instance, maybe the land was excavated and has a tunnel running under it. Now, that is a latent factor. That's not the factor that you will know by simply visiting the land and looking at the surface of the land or going to the land registry to do a search. But land title is a patent matter. Whether tenants were on the land is a patent matter. You are supposed to go there and check the land. I'm sure that there are no trespassers on the land. You are supposed to go to land registry and check and be sure that the land title is secure. So if you don't check those ones, then the court will not have mercy on you because it means that as a business person, you were careless in conducting your business. So I don't know if there are any other questions before we take our break. Okay, so I think in the absence of any other questions, we just take a 10 minutes break. I think it's better we all keep our lines open. We just give ourselves 10 minutes to stretch. I just want to drink a little water and then, so we'll be back by 6:45. So back by 6:45. Deborah, I hope that works. Deborah, 6:45, right? we can come back by 6:45?
Yes, it does, sir. I think probably she's having network issues.
Okay, perfect. So I won't go off the line. I encourage you not to go off the line. You could just mute and let's wait till 6:45 and we continue. So thanks and see you on the other side.
Thank you so much. So everyone, see you at 6:45.
Okay, so I guess we are good to go. Just give a minute for people who. Okay, I guess everybody's pretty well still here, though I see the numbers dropped a little.
Yes, dropped. Let's hope they get back in.
Okay, fine. So we'll just start in a minute. Okay, good evening, everyone. So we'll get going for the last lap. So I guess for this class, we should be, well, okay, so we need to move with some speed. We need to be done with this last lesson by 15 past 7. So we could use the last 15 minutes till 7:30 for Q&A. So lesson 3 is a pretty short one. So we're looking at common contract issues in the Nigerian business space. In the course of discussing, I've touched quite on a number of them, but we just want to hone in on a few of them and, and try to examine how these things play out in practice and some of the measures you can take to safeguard your business. So the first is something we have mentioned over and over again, and it's one of the enduring lessons I want you to go back with. Issue of privity of contract, so third-party interest, and then how you can use guarantees to mitigate against the challenges that could arise from this. So, of course, like we've mentioned earlier, privity of contract means that the person who is not a party to the contract cannot sue on the contract. That third party, of course, cannot sue to enforce the contract, not even where the contract is for his benefit. We even gave a more extreme example arising from the question asked, that even where you as a parent, you pay for hostel for your child and their issues, except you are the one who put your name on the agreement, fine. But if you put your child's name there as a tenant, then you cannot be the one to now arise to enforce on his behalf, except of course if the child is a minor, then you can enforce, even though he still put his name there and put suing through you as his next friend or his guardian. So third-party interest is something you should always watch out for. And the other time, also watch out where your company is a third party benefiting from people. So some of the things you do is either you make it a tripartite agreement, like we mentioned when I believe it was even at was it I believe it was Gladys that raised the issue of where acting as a consultant and fundraiser. So if you are the person who is a third party to the contract, you need to watch carefully. The simple solution is make yourself a third party to that contract. So where, for instance, maybe you have I'm trying to look for a very practical example, like the people in the software development space, for instance, you have all kinds of third parties who who have to you are doing transactions with, and sometimes those parties are depending on another person to supply them the service or the goods that they are going to supply you. So sometimes, to be on the safe side, you insert yourself in that agreement. Let it become a tripartite agreement, so that if any of the two of them misbehaves, you can go after them. Not that you go after the person who misbehaves and says, "Look, I don't have a contract with you. It's with your with the other party I have the contract." And it also means as a business, when you give out contracts, you always put a clause there that says the other party cannot subcontract without your permission. So you shouldn't now tell somebody, supply me something, maybe in EPC contracts, for instance, which is, subcontracting is a huge thing in EPC contracts. And in fact, subcontracting to many generations, because one person, Julius Berger, gets a contract to do the bridge. He subcontracts all the excavation works to somebody. That one subcontracts the hydrology part to another person. That one subcontracts, there's some contracts, so many chains of subcontracts down. So as the master contractor, you want to be in control. So you need to put clauses in your agreement that says you can't subcontract without my permission. So that when they bring that subcontractor, you may decide, okay, look, insert me in that agreement so that if that subcontractor misbehaves, I can come after him. Like, even though ideally you don't want that, because the idea is you don't even want to expose yourself beyond. But sometimes when the subcontractor or the other party who is not directly connected to you is critical to the success, you might want to have that relationship. Now, another interesting part of privity of contract also, if you remember from our first lesson, our first class, sorry, on business structures, we mentioned that limited liability companies are entities that the law gives a separate identity from the owners. So it means, therefore, that when I come to you, for instance, and I have a company, Max Global Limited. Now, Max Global Limited may be a one-man company. I'm the only director of the company. The other director is just maybe my wife. The other, my wife are also the shareholders. I run that company. I have an ATM card to the account of that company. And I come to you and take a loan from you. And by the time you're expecting me to pay back the loan, after 6 months, and I tell you that the company has gone bankrupt and the company has folded up. But yet you see me driving a luxury car, you see me affiliated on that company and I have money. By normal company law, you can't come after me to get your money, even though I'm the human being who collected your money, provided I collected money in the name of the company. So I've mentioned that because of that, the dangers of dealing with limited liability companies, one of the dangers is that sometimes you are dealing with a company, but the company doesn't look credible, or the company is dominated by one human being. Part of what you can do to avoid problem of privity of contract is that let that human being that you are seeing become a guarantor in the contract. So it becomes a tripartite contract. So you and his company enter the transaction. He will now join personally as a guarantor of all the obligations and the liabilities of his company in that contract. So if anything goes wrong and the company, he folds up that company and tries to do something else, you can go after him and seize his car or seize his personal asset. So in that kind of transaction, it will be a tripartite agreement where you will sign, he will sign on behalf of his company, and he will sign again a second time on behalf of himself in his personal capacity. So that's one way to handle the dangers of privity of contract, which, like I say, is a huge issue. It's always arising. People enter contracts, they forget. Sometimes you enter the contract, it's a subsidiary company. So you enter a contract now, maybe with Julius Berger to build a house for you. But Julius Berger has a company called, I think, Abumet. They're the ones that do interiors, woodwork, and all those things for Julius Berger. And Abumet is the one who comes to do your kitchen cabinet, and there's a problem with the kitchen cabinet. Abumet is the person you are seeing, but you can't sue Abumet because you have to go back to Julius Berger, who was the person who did the contract with. So these are real issues that always arise. So you have to be careful because sometimes it happens unknowingly. It could happen that, okay, when Julius Berger started a contract with you, they later formed a subsidiary and moved over the responsibility for maybe what they call maybe the responsibility for wiring to that new Julius Berger subsidiary. And maybe it's Julius Berger Nigeria Limited, Julius Berger Cables Limited. So you almost think it's the same person, but it's not. As far as the law is concerned, they are different. Julius Berger Nigeria Limited is different from Julius Berger Cables Limited. No matter how close the names seem to look, they are different. So you need to put all these measures in place to protect yourself. Now, the second common contract issue is contract management, and precisely in Nigeria, the lack of contract management. Now, people sign contracts in Nigeria and they just think that's the end of it. I've signed the contract, and all, but that's not the end of it. So I believe somebody asked about real-time monitoring of contracts. Now, this is one of the areas where that becomes an issue. Because you need to understand that a contract is not necessarily self-enforcing. I mean, people have to look at it. Contracts contain a lot of things. It contains timelines, it contains obligations, it contains steps, it contains triggers, it contains conditions, all kinds of things. So, for instance, one example of where contract management is highly necessary, which I already alluded to in passing, when we're discussing force majeure, is the force majeure clause. So, just by way of definition, contract management is just to monitor every stage of the contract to ensure it is fulfilled. So, starting from ensuring that the contract is documented, is written, it is signed by the parties that need to sign it. If it's a kind of contract that needs a lawyer to notarize, it is notarized. Copies are distributed to all the parties. Everybody keeps his copy. The commencement date, what needs to be done to commence the contract is done. All those different steps are fulfilled. And if there's any step that is not fulfilled, that a letter is written to say, look, by the basis of our contract, you're supposed to make your payment on the 30th of June. We have not received the payment. Kindly note that if you do not make the payment in the next 1 week, clause 2.3, which says you will pay 10% interest on late payment, will kick into force. So you need to that follow up and management and ensuring that everybody's respecting what the contract needs to happen. So, like I said, the typical example of contract management is force majeure. Now, force majeure clauses are not usually blanket. They don't just simply state that if an event, unforeseen event happens, obligations are suspended pending when those unforeseen event is brought under control. But usually to state things like, number one, you have to give a notice to the other party that the force majeure event has occurred. You have to give him an idea of how long you think it will take to bring matters under control. And then, and all of that. So these are things that proper contract management makes sure that you check those things and do them. So in Nigeria, it's a huge problem. People just sign contracts and go to sleep. So by the time a person now breaches the contract, you now find that if you dig up the contract, you yourself too, you have been carrying on in a way that is contrary to the contract. Not that you have breached per se, but you have not been following the strict letter of the contract. So when you try to enforce, the person can realize, even you too, you have not been following the strict letter. You are supposed to write me a letter. You did not write the letter. That is why I did not do my part. So you have to monitor your contracts, very carefully. Look at it regularly. Sometimes, I mean, for large contracts, like people do EPC contracts, they use what we call FIDIC contracts, some very gigantic contracts. Those things have timesheets and all kinds of things that state, okay, when is this expected? When is that expected? So there's like, you plot it out on a calendar. You can even use a simple tool like Google Calendar, put a reminder on Google Calendar that 3 months before my rent expires, I'm supposed to write to the landlord to inform that I want a renewal. You can put a reminder on your Google Calendar, from now against 9 months from now. So that 9 months, it just prompts you. You remember, then you write that letter and send out to your landlord. So contract management is important. It's usually something that you should have a department for, or at least as a small business, you should be able to do it yourself, but just organize yourself and make sure you understand all the details of your contract and you are following all those steps one after the other. Then another huge issue is dispute resolution clauses and alternative dispute resolution or arbitration, ADR and arbitration. Now, everything is subject to agreement, including how to disagree. So you can put in your contract that if you want to disagree, this is how to disagree. You can also agree to disagree or how to disagree in your contract. So a dispute resolution clause simply one of the clauses in your contract that states clearly what happens when there's a dispute, how should it be resolved, who should do what, how should a person go about it. So one of the ways to do it is what we call a multi-tiered dispute resolution clause. So a multi-tiered dispute resolution clause is simply a dispute resolution clause that has different stages of how to attempt to resolve the dispute, and you manage the dispute so that way you only escalate disputes that really require higher levels of resolution. So typically, a multi-tiered dispute resolution clause will first say that the first layer is negotiation. If there's a disagreement, like in a joint venture, let the senior management, and you define what senior management means, at least somebody in the board of directors or executive directors of the company, should meet and discuss how to resolve the challenge. If they are unable to resolve it, then parties should go to what we call mediation. Mediation is a private means of resolving a dispute where you call a third party to help both of you reach an agreement by looking at different options. It's kind of negotiation, but it's just it's a little bit more formal than negotiation. Negotiation may only be two of you, but mediation always involves a third party, usually a trained professional whose profession is how to resolve disputes, how to know where people are arguing from, how to get people to see things from the right perspective and to reach an agreement. So if the mediation is able to resolve the dispute, what is signed is what we call a settlement agreement, which is another agreement which states, okay, this problem arose, so now we have agreed to solve this problem this way. Instead of paying the 10 million naira, pay only 8 million naira. But however, instead of waiting to be, instead of giving the person only 6 months to deliver, give him 1 year to deliver and pay him only 8 million. So that's a new agreement that has changed the original agreement. So that's one way to resolve. Now, if that fails, then you can move on to what we call arbitration. Arbitration is also a private means of dispute resolution, where a third party sits the way a judge will sit in court to resolve your dispute. So both of you make arguments to him and he gives a decision. The difference between it and litigation or going to court is that in court, courts are set up by the government, the judges are paid by the government, and they are put there to resolve your disputes. So you usually don't pay too much. The government subsidizes the cost because the government pays a salary to the judge. You don't pay this judge every time you come to his court. But in arbitration, you are the one renting the man who's going to sit as a judge over you. So you have to pay him for his service. So because of that, arbitration can be quite expensive and some arbitrators charge based on percentage. So you come to arbitrators, you have a case of 100 million. The secretary pay us 5% of the 5% as our own fees for sitting as an arbitrator over your case. So you'll be paying 5 million. Whereas if you go to court, filing fees and all of that in court would highest not exceed maybe 100,000. Of course, usually what's expensive because that you have to pay your lawyer's fees. But in arbitration, you are paying that 5 million first to the arbitrators, and you still pay your lawyer's fee, which will not be cheaper than what you would have paid him if you had gone to court instead. So arbitration can be expensive, but what is the advantage? That's what we should dwell on as business people. Now, normal litigation, judges are just trained lawyers who have over the years distinguished themselves and they have been made judges. They may sometimes not have experience of business. So, but arbitrators can be anybody. Typically, it's lawyers, but it's not always lawyers. It can be an architect. So if you are in the EPC space, for instance, lots of time architects, quantity surveyors sit as arbitrators. So imagine having somebody who is knowledgeable in the industry sit as a judge over your case. So by the time a party is talking nonsense and saying in this EPC contract, when we're digging the subsurface structure, we have to spend 10 million. If it's somebody who's in the industry, he knows that there is no substructure that can cross 1 million. So you know you're already talking rubbish. So you can see that your case has a greater chance of finding justice in the hand of somebody who understands and knows the industry more than a judge who has never done construction in his life. It's only the argument that lawyers give to him that he will use without really knowing some of these details by himself. So these are some of the advantages of using arbitration. It's also flexible. You can design how you want it. You can also make it confidential. Next class, when we talk about intellectual property, one of the things we talk about is what we call trade secrets. Sometimes you don't want the whole world to know the quarrel you are having. You just want to go to arbitration. The thing is held in a lawyer's office somewhere. Everybody is made to sign an oath that nobody's going to disclose what happened in this case, so that way confidentiality is maintained. Sometimes also, because it's not court case and all of that, parties might be more friendly even after it finishes and still be able to do business together. But when you take people to court, relationship is ruined. It's usually impossible to salvage a relationship that has already gone to court and to still carry on. And then because this, like I said, is also flexible, you can control a lot of things. You can choose the language to be used. You can choose even the law that will be used. So for instance, somebody's coming from China to do business in Nigeria. He's definitely going to feel that if a case comes up and a Nigerian court is going to judge the case, the Nigerian judge will favor the Nigerian. If you are doing a business in China, you also feel that if this case is held before a China court, the Chinese man will favor his brother, the Chinese judge will favor his brother, he won't favor me in Nigeria. So arbitration allows you, for instance, to agree that you are coming from China, coming from Nigeria. If any dispute arises in this case, the arbitration must hold in London. The law will apply will be Nigerian law, but the rules that will govern it will be the London rules, and the actual hearing will be in London. You can agree that it will be in France and the French language will be used. You can design your dispute resolution the way you want it to be. So these are parts of the advantages that kind of offset the disadvantage that is expensive. You can also choose to have more than one judge. You can choose to say, look, let it be 3 arbitrators. One should be a quantity surveyor, one should be an architect, one should be an experienced lawyer. So the quantity surveyor is able to give experience of quantity surveying, the architect is able to give that, the lawyer is able to help them balance, ensure they follow the rules and that they don't breach any of the rules that will now make the process to be null and void. So you can see that it's a huge advantage, but you need to just understand before you put an arbitration clause in your agreement. Understand. So if you have a low value transaction, as far as I'm concerned, any transaction below 100 million is a low value transaction. You shouldn't put more than 1 arbitrator, because if you put 3 arbitrators, 3 of them may charge you 5 million, that's 15 million, and you have to pay the money up front before they give you judgment. So it's not as if, and there's no guarantee that after you pay the 15 million, you will get judgment. You may lose, and of course the other party too, but typically both parties contribute equally to pay them. So you will pay 7.5 million, the other party pays 7.5 million. Sometimes, of course, if you are not taking that party to arbitration, he will decide not to show up or he refuses to pay. You'll be forced to pay his own, and then hope that if you win, they'll now order him to pay you back your 7.5 million you paid for him, along with whatever damages they are worth to you. So you have to know how to negotiate your dispute resolution. But like I said, the good thing about it is that it gives you freedom to design the process the way you want. Then the next thing is capacity of foreign companies to contract in Nigeria. Now, foreign companies can sue and be sued in Nigeria. So if, for instance, there's a practical case, a foreign company supplied tractors to a Nigerian company to display in a trade fair. When the trade fair finished, the Nigerian company sold some of the tractors, refused to remit money to the German company. The German company came to Nigeria, briefed the lawyer, and they sued the Nigerian company. And the Nigerian company raised the issue and said, after you're a German company, you are not incorporated in Nigeria, you cannot sue before a Nigerian court. Because they know, the law will not allow itself to be used as an engine for fraud. If you are owing people, go and pay them their money, don't run and come and tell us that because the company is a foreign company, cannot sue you in Nigeria. So foreign companies can sue and be sued in Nigeria. However, foreign companies cannot enter contract to operate in Nigeria except they get registered in Nigeria, which is where joint venture that we mentioned comes in. So if a foreign company comes to operate in Nigeria, then it needs to incorporate with its Nigerian partners a joint venture that will run its business in Nigeria. And the law on that is simply also what I told you about illegal contracts. So by the Companies and Allied Matters Act, a foreign company incorporating in Nigeria must register in Nigeria. It's only allowed to operate in Nigeria where it opens a representative office to allow it preparatory to incorporating in Nigeria. But if you are going to do business in Nigeria, now it's a different matter if the transaction, the contract the foreign company enters for is to be performed outside Nigeria. So if a Nigerian company enters a contract with the foreign company to sell maybe pharmaceuticals from India, and the pharmaceuticals are produced in India and shipped from India, you cannot now run away and say, because the contract, the company is foreign company. No. It's only the company says they are entering into Nigeria, maybe to establish a factory. So the practical example is, if you know Mbora Estate in Abuja, in that Jabi Airport Road, that's the classic case where the Supreme Court held that foreign companies cannot enter contracts in Nigeria. So the foreign company that developed that estate entered into a contract with a Nigerian company to set up a factory somewhere within the estate. Issue dispute arose, and the foreign company took the Nigerian company to court. And the Supreme Court said, no, You're a foreign company, you have not registered in Nigeria, you don't even have a right to enter Nigeria and set up a factory, not talk of entering a contract with somebody else about a factory, and therefore, the court will not allow them, allow that claim go because it's an illegal claim. It's contrary to what the law says in the Company and Allied Matters Act. So that's also another important. So also, if your business is expanding abroad, then you should know that you need. I believe in our last class, we discussed what we call a Delaware flip, which is where you incorporate a company abroad, typically in the US, in the state of Delaware, and then you convert the shareholding of your company to that company, so that that American company becomes the owner of your Nigerian company, and that way your company suddenly becomes an international company, with many things, prestige of operating as an international company, and all of that attached to that. So if you are doing if you are going to business outside of Nigeria, then watch it carefully and ensure you get there. And also, if you have a foreign partner coming into Nigeria, of course, because you're a person of integrity, you don't want to cheat them. You let them know they need to incorporate an SPV here in Nigeria so that the law does not view whatever contract that you have. Because remember also that if you do a contract with them and the contract goes bad and you are the one suing them, they can also rely on this and say, after all, you and them entering this contract was an illegal contract, so you can't sue them and you will lose. So you better know that if you are going to do the foreign company, insist that they register in Nigeria or they appoint an agent, give the agent the power of acting in Nigeria to act as their representative. So if anything goes wrong, you sue that their agent. Then finally, we'll talk about damages, particularly the damages we call anticipated profit and interest. Now, like I mentioned earlier, I think when we're talking about damages and we're talking about that the purpose of damages is to put you in the position that you would have been if the contract was not reached. So that means it's not just about how much you pay, but the benefit you should have gotten. So sometimes you enter a business, for instance, a joint venture agreement, and the joint venture agreement is projected, maybe the joint venture agreement between I and Nnamdi to distribute pharmaceutical products. Excuse me. Between I and Nnamdi to distribute pharmaceutical products in the South. So by the time we entered an MOU, Nnamdi now did the scoping and everything. I saw that the market is huge, that he expects a market that the interest, the profit, that we should be making in that market every year should be about 500 million. He has done the analysis, everything has gone well. We now sign a distribution agreement, start the distribution agreement, and then suddenly I now breach that agreement. Now, when Nnamdi sues me, like we mentioned, the damages that Nnamdi wants is what will put him in the position he would have been if I did not breach the agreement. So the question is, what is the position he would have been if I didn't breach the agreement? The position that I've been is that the company that I've been running, I've been making profit of 500 million, and based on our agreement and our profit sharing, he should have been getting maybe 40% of that. So he should have been getting 200 million every year. But because I've breached the agreement, I've denied him of the privilege to be able to make that 200 million every year. So if he is suing, that is what he should be claiming, that I have been deprived the opportunity of making 200 million every year. So court award me that 200 million for the 2 years that this agreement was supposed to run, that Marx did not allow the agreement to run. But however, to prove and get anticipated profit is a tough matter. Nigerian courts put a very high and strict mark on it. So you have to have impeccable records to justify that. So for instance, in this scenario, you need to have all the market analysis, including a proper market survey done by a proper consulting firm. Maybe New Consult had done a proper marketing survey for him. He needs to show, you need to prove to the court that truly that profit is not speculative, but it's realistic profit. So sometimes in your agreement, you could put it there clearly that a breach of this agreement entitles the party to also get anticipated profit. So you put it there clearly so that the court sees that yes, parties foresaw that anticipated profit will be an issue in this matter. So you need to keep records. You need to also make it clear in your agreement that anticipated profit. Now, interest, of course, we know what interest is, where there's delayed payment or where there's an obligation to pay and the person doesn't pay. Because of the, I'm sure one of your classes have already covered this, time value of money and all of that. So interest is simply a marker you put on money, just as a rate of return over time to represent the time value of money over the course of time. Now, different jurisdictions or different countries tackle the issue of interest differently. In Nigeria, interest is viewed as what we call special damages. So just like anticipated profit, you have to prove it. So you have to show, you have to show that interest actually was factored into that agreement. So one way to show that is that if customarily in that line of trade, interest is normally paid. So if you are doing a banking and financial transaction, for instance, the court will assume that in a banking and financial transaction, interest is a normal thing to be paid. But if you are doing, for instance, maybe something in the pharmaceutical industry now, because we are not sure if interest is usual, it's a usual element of the pharmaceutical industry. So you might need to now prove that in this our case. So one way to prove is that if the agreement states clearly that any payment due under this contract which is not paid will carry interest at X amount, then you are good to go. Because note that what you are proving is not just the fact that interest should run, but the amount of interest that should run. So the best way to solve the problem is put it in your contract always, that if any party fails to make payment that is supposed to pay within 7 days, then the money will carry interest at XYZ amount until liquidation. This also ensures that when some people who just want to be mischievous, who owe you money and say go to court, after it's in a Nigerian court, you'll be there for the next 20 years. At least while you're there 20 years, you know that your money is growing interest over that time. However, note that in pre-agreeing your interest, there's what we call a penalty. Penalty simply means when you put an amount on somebody that is not a genuine estimate of the value that you are going to lose if the person breaches, but rather it's like a punishment that you are going to punish the person if he breaches. The law would nullify it. But there's what we call a liquidated damage. The liquidated damage is when you do an assessment of what you will lose if the person breaches. So an interest that follows, for instance, the market interest rate will be viewed favorably and will be upheld by the court. So if you say interest rate of 18%, it's not far off the interest rate that banks are charging in the economy. So the court will uphold that. But if you say interest rate of 70%, then the court will say no. That sounds more like a punishment. That doesn't sound like a genuine estimate, except if you show that that particular line of business is so profitable that the interest in the line of business is so profitable that 70% is not unusual as a return on investment in that line of business. Fine and good, then you'll be able to claim that as interest as well. So these are things that you need to put specifically in your contract, because Nigerian law does not presume or assume these things, and proving that the thing is customary in that industry sometimes can be difficult. So the best bet, put them in your contract to ensure that you are able to argue and recover them. Yeah, so we've come to an end. Thank you for being a wonderful audience. So we have I guess this is 12 minutes more so for Q&A. So 12 minutes more questions. Yeah, questions?
Thank you very much, sir. Do we have questions? Yes, sir. Do we have questions?
Okay.
Okay, let me just ask this. Earlier when you were talking about breach of contract and all of that, you mentioned something about discharge, and you said something about, you cited an example and something about remote reasons being too remote. So you said something about a warehouse and probably the condition for payment or the condition for that particular negotiation was the fact that there was supposed to be a rail line that was supposed to be situated. So you said it would be too remote. The reason would be too remote if maybe Farida, for instance, now Farida entered into a contract because she thought that there was going to be a rail line, and the rail line was later cancelled, and in that case she lost the money. So I'm saying now, if I want to go into that kind of arrangement with somebody, into that kind of negotiation, do I include it in my contract to make sure that in case of a situation like that, I am covered? Because the damages may not be paid, as you earlier said, in that situation. So I'm saying, is it possible, or is it legal to actually include a clause that says in lieu of blah blah blah, this because there's a real way, blah 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 blah. Does it count as a legal reason or a legal part that can be put in a contract?
Okay, yeah. Thank you. That's a good question. Now, one way you can mitigate against that kind of thing is you could state it clearly. I'm entering into this agreement or this negotiation because, and it should be stated in the agreement, there's what we call the recital, the first part of agreement that gives a background to why parties enter this agreement. You could state it there clearly that parties have entered this agreement because government's about to put a railway here, and Farida already has potential off-takers who are willing to pay as high as 10 million for lands in that place, whereas lands ordinarily there are 5 million. So that when that breach happens now, it is already shown that parties had anticipated that that if this contract fails, Farida is going to lose what would have been a difference of 5 million. So that when the contract now is breached by me and Farida is suing me, I say, in our agreement, you stated it clearly that if you fail to deliver this land to me, I will lose making 10 million from off-takers who ordinarily, if relay was not there, would pay only 5 million. So because you breached the agreement, I've lost that value. So at that point now, those damages will no longer be remote, because when the court is talking of remoteness of damage, what the court is looking at simply is it reasonable that when parties were entering into this agreement, they foresaw this this issue happening and made provision for it. So if you show that this is why, and that's why it's good to always have a recital that states clearly why you are entering into an agreement, or sometimes maybe letters that are exchanged before that state clear that we're entering into this agreement because we have seen this opportunity. So let me give a practical example now. For instance, in the transaction between I and Nnamdi. Now, if and Nnamdi had agreed that I was selling pharmaceutical products that he was selling in the Niger Delta, and as at the time, maybe let's say those drugs are powerful anti-COVID drugs, and because of that now, because COVID is raging, and we agreed, okay, start supplying me this thing in 2 months' time. And at that time, because COVID was still a hot issue, people were ready to buy that drug 1,000 naira per unit, whereas that drug normally should be 100 naira per unit. But people were ready to buy 1,000 naira per unit. And we entered that agreement. And I now delay and don't supply the products until 6 months after. And because of my delay, another German company now also produces a similar type of drug and appointed a distributor in Niger Delta who is now selling the product there, maybe selling at 800. So that by the time Nnamdi now also brings his own into the market, Nnamdi has to now sell at 700. Then the guy now sells at 500. Then two of them now do that until they're now selling at 300. So if Nnamdi sues me now, he will say, look, for that first 6 months, before the German product got NAFDAC registration, if Marx had supplied me these drugs, I would have been selling at 1,000 naira per unit, at least for that 5 months. I would have had a monopoly of selling 5,000 naira per unit, and this is how much I would have made before this German competitor came into the market and crashed the price. So you can see that he has a basis to make the argument, but the court is now going to ask whether that damage is not too remote. That if somebody is selling a drug that should sell at 100 naira, the unusual circumstance that COVID will come and make the price go up, or NAFDAC could delay giving approval to another person and all, were all those things in your mind when people were contracting? So if those things were not in your mind, then the court says it's too remote. Marx will not pay you any extra money. It's not his fault that the German people crashed the market. But if you had put it clearly in some of the emails or the earlier agreement that we need this contract to start in 2 months' time because we want to take advantage of the market before competitors will come in and all, then that way it will not be remote anymore. So I hope you get that now.
Yes, sir. Thank you very much, sir.
Okay. Okay, so any other questions? Because I'm going to start asking my own questions now. We'll do like a quick review. If I don't see any questions, I will ask my own question. Okay, so good. So let me do my own questions now. So I'll ask and I'll just randomly call people to give it a shot. Let me see, who am I starting with? Whoever's okay. So whoever I see first here is the person I'm starting with. Sorry, just give me a minute. Okay, so I guess who I'm seeing first here is Wonder Gold. So Wonder Gold.
Yes, sir.
Yeah. So just to, I'm seeing the kind of question I'll ask you now. So, okay, just to ask you this question and hear your opinion. Assuming FCDA enters a contract with you to build AMAC model market in, say, Kubwa. And part of the contract is that how you will be paid. AMAC will be allowed to manage the market. They are going to be collecting toll from everybody that comes to the market. And at the end of the year, whatever AMAC collects, you will get 50% of it as part of your payment for building the market. And at the end of the first year, AMAC has gone to appoint another person as the consultant. And that one, after collecting all the money, first of all, took 50% of the money and then remitted only 50% back to AMAC. And AMAC only paid you 50% of that 50% instead of 50% of the total figure.
Yes, sir.
Would that be a breach of your agreement? Would that be a breach of the agreement you have, the agreement that was entered into? Okay.
Yes.
And who will you sue? Who will you sue in this case?
FCDA, sir.
Excellent. And that's because of privity of contract, right?
Yes, yes, sir.
Excellent. But from all we have said, how would you in this case protect your interest if you are caught in this kind of situation? What are the steps you would have taken to protect your interest?
Okay. So other than spelling out, maybe we might want to get another party that would have records of the finances that comes in, and probably, I don't know, how all the monies, who the monies will be paid to, but I was thinking that probably there should be a third person who is in charge of the funds, and then both of us have access to knowing how much came in and at what point, you know. Well, it's a federal parastatal, if I'm not mistaken, so I cannot probably please them to do something, but I know that I would take measured efforts to ensure that I'm carried along in the funds, and just basically I spell it out in the contract. I'm still learning this.
So in this case, which contracts? Let me just understand, how will you do the contracts?
Okay. I'm trying to. There'll be a deed. Absolutely. I'll go with a deed.
Okay.
It's obviously signed, sealed, and notarized by a reputable legal firm. And then okay.
Okay, so let me ask you, do you think making it a tripartite agreement will be good? And who will be the third party you want to add in the agreement?
Good. I think that's the word I was looking for. I think making the tripartite agreement is good, and I might want to. I want to make a legal firm the third person.
So essentially, what I guess you're saying is that that company that AMAC is bringing, you can make them a third party to the agreement, or you can make AMAC themselves a third party, so that way you can sue them directly. You don't have to go back to that. You can have direct connections with them.
Yes, absolutely, sir.
Okay, good. Thank you for that. Then let me go to I've done a guy, so let me do a lady. So Farida, our real estate person. So I think the next question is coming to you. Farida, can you hear us? Okay, but it seems Farida can't hear us. Let me see. I'm looking for somebody else who is in real estate to ask. So Farida, and then there's somebody else who also did real estate. Why am I not? Okay, I don't know if I disclose that properly. Okay, but it's okay. Okay, so let me just ask. Let me see who next I see on my. Okay, so I'm seeing Stephen. Stephen. So Stephen, can you hear me?
Yes, okay. I can hear you, sir.
Okay, so simple scenario: you are developing an estate, and Wonder Gold comes to buy a house, but says he wants to buy the house in the name of his children, just as a way to appreciate them and to show them that he loves them. Is there anything you'd like to put in that contract to give you full protection and to ensure that, at any point in time, if anything goes wrong, you're able to sue Wonder Gold directly? Stephen, what will you do in that contract?
Like, he's trying to buy a house for his children.
Yeah, he wants to buy a house in your estate, but he wants you to put the name of his children in the contract.
Okay.
First of all, is that contract enforceable?
I'll check if.
The first question, would that contract be enforceable?
Yes, it's possible.
Okay.
The contract,
and why would you say that, considering that they are children?
Yeah, it can do that in proxy.
Okay. But from what we said, considering that they are children.
You can do it in proxy. Maybe
from what we said.
Medicine interloper.
Yes, sir.
So, but Stephen, I say from what we said, considering that they are children,
yes, sir.
Will you be able to, assuming the man Wonder Gold doesn't pay the balance, will you be able to sue the children, or what will you do?
I won't be able to sue the children because from what you said earlier, they're not up to 18 years.
Good. So what will you now do to protect
there
yourself?
There are some things I have to put in place.
So like what?
Yeah,
what will you put in place?
I have to put in place. Yeah.
So an example of one thing you could do to make sure you can sue their father and it doesn't escape.
Okay. Okay.
Yeah.
Okay,
so anybody who wants to give
it
a shot. Yes, Deborah. Yeah.
You said in the contract there could be a clause saying through so that's through.
Exactly. So essentially, you could make the fathers a guarantor in that contract. That if any of the obligations on the children is not fulfilled, the father guarantees, and then that way you can sue him. You can sue him directly. Okay, then. So let me ask another person. So I can see. So Mnamdi Mbachu. So Mnamdi, the question I want to ask you is, let me see. Mnamdi, do you see any challenge with me giving you? Is there any challenge with me giving you an exclusive distributorship agreement to sell pharmaceutical products in South-South? Is there any challenge? And can you remember any challenge you mentioned in the course of the lecture? Or any reason why I should not be able to give an exclusive distributorship agreement?
Okay. If you There are challenges because then I'll have to do some researches, right? And I will not be able to sign off on anything till I know how feasible it will be.
Okay, well, yeah, you're talking of you're talking of from the viewpoint of MOU and letter of intent, yeah. Okay, but the point I was making, just so you remember, is remember that under the Nigerian Federal Competition and Consumer Protection Act, you can no longer enter into exclusivity agreement. Yeah, so even if you must, then there are ways you have to, some things that have to be done to make it possible. But outrightly, you can't just enter into exclusivity agreement. Okay, well, Farida, yes, I just saw your chat. Farida, if you're in a good place to speak now, yes, I still want to ask you something else.
Good evening, sir.
Okay, so yeah, look at please, carry on. If you have a question, you want to answer any of the questions you have asked, please carry on.
Good evening, sir. It's just the question that you just answered, the question you asked, Nandi. I think the main thing about it is just for somebody to know the law. And because these are eyes opener, the explicit bill that is no more practiced in Nigeria, I believe everybody can fall victim of it because once the law is the law. Once you know, you know. Law is not an ignorance. Nobody will say because you don't know. As you asked the question, I was thinking Inadi will just go straight that the first challenge is that he cannot do it because it's not avoidable in Nigeria.
Yes, because the law has
everybody which because every other technicality may not matter. But so we should hold it and we should not forget it. If anybody wants to sign up for exclusive agreement, we should at least let the person know that it's not avoidable in Nigeria anymore. So if there's any, so I'm waiting for my own question, sir.
Okay, very well. So let me take you up with. Can you remember the difference between a term sheet and an MOU or letter of intent? So first question is, a letter of intent and term sheet, are they binding or not binding? That's for you.
Okay, thank you, sir.
Yes.
Like when you are taking us through the lecture, you let us understand that MOU is not binding. It's just like a guideline.
Excellent.
It's just like guidelines to what to come. So, and you give a case study of a company that was signing a MOU and it was already spending money. And at the end of the day, lost out because the proper contract has not been signed. So when the new government comes, they push them out and they go to court, even to the Supreme Court, and they lose out. And
excellent.
The difference between them is a time sheet is like a bullet point outline. Is condition of the is an agreement of the condition of the work, not the real work, but the just how it's going to be run. So
excellent. I already give you 100. I give you 100 over 100. You got that spot on. Well done.
All right, well done. Thank you, sir.
Well done. Okay, so I see we are well out of time. So one last question, and then we call it a night. So let me see who else this would go to now. So Godia John. Godia John, if you can hear me. Okay, I don't think Godia can hear me immediately. Okay, so let's see. Okay. Or let's see who else. Richard Jeremiah. For the last question, Richard.
Yes, good evening.
Okay, Richard. Yeah. So yeah. So Richard, I want to ask you, if your foreign partner,
Okay.
if your foreign partner from, you are partner with a company from Germany and you want to work together to maybe construct something in Lagos, what kind of agreement would you want to sign with that partner? Maybe you want the Lagos government to give you contract to construct maybe schools. What kind of contract would you sign with that your partner?
Okay.
Among the different agreement contracts you have mentioned.
I would assume a joint venture agreement.
Perfect. Excellent. Excellent. And what kind of joint venture would you do? Can you buy the two types of joint ventures?
No, I can't. No.
You can't buy the
What?
I
think the network was fluctuating.
Okay, so you didn't hear that part of the two different types of joint ventures.
Yes, but I remember the narrative you mentioned them.
Okay, okay. Okay, so let's see who can tell us the two types of joint ventures and which joint venture model you advise Richard to undertake with his German partner. Who can remember? Any other person at all? You can just unmute. Okay, so maybe I'll just mention that again. So there are two kinds of joint ventures, incorporated and unincorporated. So unincorporated is where you just sign an agreement and both of you are running the business under that agreement without forming a third company. That's what we call a special purpose vehicle company. But remember, because of what we mentioned, that in Nigeria, a foreign company cannot enter into a contract to operate in Nigeria without getting registered in Nigeria. So it means, therefore, that if a foreign company is going to enter into that kind of contract in Nigeria, then you have to form an incorporated joint venture, because your company and a foreign company need to now come together and form a special purpose vehicle company or a third company, which will now be the one to carry out the contract. Otherwise, that contract will be viewed as an illegal contract, and both you and that party will not be able to enforce it in court. So at this point, we have shot over our time by 15 minutes. So I think we'll bring the class to a close, except there's any last questions. If not, we'll hand over back to Deborah. Thank you. It's been an interesting class. And look forward to our last class on intellectual property. That's actually very interesting. Might not be as technical as this, but I'm sure you'd really enjoy it. It's an area that you'd find very relevant to whatever business you are currently doing. So Deborah, back to you.
Yeah, thank you so much. Thank you so much, Barrister Marx. This has been a very insightful class. Honestly, I've never seen contracts in this light before. And thank you so much for shedding so much light into this topic. It was really interactive. I mean, I'm sure everybody would agree with me. So I just need one or two people to just unmute and express their gratitude to Barrister Marx. I mean, for a very busy person, when I asked him and he just said, "Oh yes, I'm gonna be available to take," I was so wild and grateful, you know. So please, let's just unmute our mic. The caliber of our facilitators are really high, and I want us to see it, because when the value of a thing is not known, abuse is inevitable.
Thank you very much, sir.
So it's important that we understand. Okay, Amwa Stephen has already unmuted.
Hello. Hello. Good evening. Thank you so very much. Like Madam Bele just said, it's the eye opener. It makes me like to see things like in another angle. It is not just like normal mutual understanding, or you just do not the concrete contract that you think you are in a contract. Thank you very much, sir. Very.
Thank you very much, sir, for
You're welcome.
exposing us to the instrumentality of the law. It was as an individual that plays very well in the EPC industry. I now understand why some of our competitors and some of the players I work with use the instrumentalities of the law very well. So there is no excuse for ignorance. There is no excuse for ignorance. I've made a mistake. I've seen my mistakes, and I know how to now start using the law to act as a backup to myself and my industry. So I want to appreciate you very much, sir, for exposing us, for taking out time to give us these details. I'm so grateful, sir. Thank you very much. God bless you, sir.
All right. Good evening, sir. Good evening, moderators and the host. I want to say a very big thank you to our presenter here. I want to say very, very well that the lecture has been very, very much enlightening. I am actually a manager with a mining and construction firm in Lagos. I've been getting the invite to attend this course. I must confess that I've not been faithful and religious in attending classes, but attending this particular one has really revealed and showed me the content of the program, and it is quite deep. I attend a lot of managerial meetings and legal meetings. I want to sign contracts and the rest of them. But I must confess that this lecture will really give me an in-depth advantage when it comes to signing of contract and legal matters, especially when we are discussing with barristers and legal personnel in the team. As a manager, if you don't have a knowledge of the law, a knowledge of contract management, because that is going to be very difficult for you to even engage stakeholders in any discussion. So I want to thank you very much and say a very big thank you to the host and the presenter as well. And I want to encourage everyone to really take this very, very serious. This is a program that I know people are paid quite a lot of money to attend this kind of program somewhere. And I want to say that it is very, very rich. Thank you very much.
Thank you. Thank you.
Good evening, sir.
Okay, Chibuzo, well done. Evening.
I appreciate you for your time and the energy you put into delivering this course. Actually, Mr. Nelson dropped a message. He was supposed to be around, but he had to attend to something very urgent. So he said I should extend the regards. And then on my own part, I must say that personally, this course has really been it has been very impactful and interactive as well. And considering, where I'm coming from, as in the field I'm currently operating in now, the real estate, and I see this particular course, this lecture as very inevitable because on a daily basis, we interact with a lot of contractors and, the agreements, the day-to-day decisions we make. And, I begin to see how important it is to even, come up with an agreement first with these contractors and to make the terms and conditions known because, a lot of contingencies, a lot of things could have gone wrong. So making it clear enough to some of these parties is very, very worth it. So I thank you very much, sir, for this course and the energy you put into it. In fact, it has really been impactful to us. Thank you very much, sir.
Thank you very much. It's a pleasure to be here and a privilege. Thanks so much.
Thank you very much, sir.
Thank you.
Yes, sir. I missed. I was following, even though I couldn't hear most of it, and even when my name was called, I was really in a very busy place. I was trying to get through, but I couldn't. But hopefully, I'll go through it again, and then I'll digest it more and maybe come up with my questions by tomorrow. This is very helpful. I would say I had no knowledge, zero to no knowledge about all this, and so this is like a light that is being shown, and I'm really, really appreciative of it. Thank you very much, sir.
All right. Thank you so much, everybody.
Thank
And
you.
thank you for attending. I mean, it's good enough that we remind others, since we believe that this is valuable to us. I mean, if it's valuable to you, then it's valuable for the next person, the next emerging manager or current manager that you know. So please, let's always remind our friends, our co-workers, our colleagues, anyone on the EMP to join in, because the attendance, well, today was better, really. The attendance has not been too encouraging. So if we really value this, let's invite and remind other people to join in. Thank you so much, Barrister Marx. We're grateful. So the recording of this will be made available for everyone so that we have access to it again. The recording for yesterday has already been posted, so we can go through. Thank you so much, everybody. Let's have a beautiful night rest. Thank you, sir. Yeah.
Okay,
Bye,
thank you.
everybody.
Yeah, so see you
Good
guys
night.
next time.
Thank you, sir.